Hello everybody. Today we are jumping back on the train of going through the Supreme Court's case on Dobbs v. Jackson Women's Health Organization, and we'll be reading through the concurring and dissenting opinions with PISCO. So if you're looking forward to that, have a good time. I should have it timestamped shortly after the stream is over. I'll prioritize that. That way you can hop around the timeline. If it's not done yet, then just know I'm probably working on it. And yeah, that's the dealio. I'm going to toss you guys some music while I get ready in the background, and then we'll jump into it. Talk to you in a bit.
Yo.
Hello everybody. How are you doing? I'm very, very excited for today's stream because we'll be picking back up with Pisco, talking about the Supreme Court, going through some of the concurring and dissenting opinions, which I feel like is going to be maybe a bit more interesting than reading the majority opinion, particularly reading the dissent, because I know a lot of you probably dissent to the opinion. So to kind of see the arguments from the other side will be nice. I feel like where I left us off last time, we didn't really get a taste of that. So we had a lot of arguments from Alito and from the majority opinion, but we didn't really have any pushback. In this stream, hopefully we'll get that. So looking forward to that. Yo, it's Booksmart streaming. I'm going to keep it a book fitty. Nice. Well, I hope you keep it a book fitty with me all day today. Good morning. But yeah, I'm excited to be back with Pisco because it is fun to stream with Pisco. So hopefully that goes well. I've got Pisco waiting. So what I'm going to do is get through. It almost looks like on OBS that we're having like something weird with the lighting. I don't know what it is. I'll have to ignore it for now. I think that maybe there's light getting into the camera or something. I don't know. Anywho, I do have a bit of an ad read that I have to do before we hop into it for today. So let me get out my phone real quick so I have my notes in front of me. That'll make things 10 times easier. So 1 second here. All right. So hashtag ad, hashtag sponsored, whatever other kinds of disclosures I need to give you. We have Into the AM, who has been a sponsor before on the stream. You might remember them from way back when, maybe over a year ago now. They're back. And they're happy to sponsor the stream. So if you ever see me wearing like graphic tees like this, and we have some space aliens or astronauts or, oceany stuff or mushrooms, all that's coming from Into the AM. They're a clothing company. They make graphic tees, hats, shorts, hoodies. I can particularly recommend the hoodies because they're affordable. They're like super duper comfy. It's not often that I get a sponsor that like I'm willing to take on because I have to like the product. I've had many products sent to me where it's like, this is like complete trash. There's absolutely no way I would push this to you guys. Whereas with Into the AM, like half of my luggage is just full of Into the AM stuff. So, the shirts have lasted. They're not falling apart. They don't like tear or anything like that. It's been more than a year that I've had the clothes and they're still good. They have sales all of the time on the website. So I would highly recommend that if you need some shirts, or particularly if you need a hoodie, they have really nice stuff, and you can get 10% off if you use my code or if you use my link. So if you do ! Into the AM in any of the chats, then you'll get a link, and it's basically just like intotheam.com/booksmarts. And then there'll be a kickback to me for anything you buy on their site, and it lets them know that these ad reads are working. So definitely, if you're in need of any kinds of clothes, check it out. They always have sales going on, so you could find super cheap t-shirts or super cheap shorts or whatever it is that you need. And I would highly recommend that if you do need clothes, go out there and check it out. They also have some really cool jackets and stuff, but it depends on what you're looking for. Like if you go out and you do jogging or you go walking in the morning or at night or something, they have a really cool like reflective jacket that you could get. It's not necessarily going to keep you like super warm, but it is going to be like a cool design, and it's going to be something where you're going to be visible to people on the road or different cars or stuff like that. But I really think that like their bread and butter is like the t-shirts and the hoodies. Those are what I could really, really recommend to you. They last forever. The designs don't come off in the wash. Like, again, I cannot emphasize this enough. There are other clothing companies that have wanted to work with us, and it's like their shit falls apart after like a few washes. Like it can be really, really bad. And Into the AM is like really, really good. Again, they're more than half of my luggage. I would highly, highly recommend them. So feel free to check them out. Again, you can use ! Into the AM to check them out. And thank you to Into the AM for sponsoring this stream. We'll be talking about them for probably the next 2 months, and we'll see if they want to do more after that. So just keep that in mind. How do you feel about not being in the U.S. for the 4th? Indifferent or a little disappointed? I mean, I'm not in the U.S. for the 4th like all the time, so I don't know. When I'm paying attention to the dates, it can feel bad, but I don't know. What's going to be weird is in being in the motherland. Being in the UK during the 4th of July is going to be a little bit strange. I would say that's the strange part of it. The background is a little bright, but I don't know how much of an issue it is. I wonder if I could... There has to be some way of doing this. The problem is that we're going to have like the Supreme Court case like right here. So that's something that we need to do. Anywho, now that our ad read is over, I can go ahead and give Pisco a call here. He says he should be ready in a moment. Oops, I sent him caps. I hope he doesn't think that we're in some giant hurry or something. I'm sure that we still have people rolling in, so there's no rush to get started necessarily on this. As a bit of a TLDR of the last time that we did this, which again, it's all time-stamped and it's a VOD on YouTube, so if you're interested, check it out. We go through the entire majority opinion. Basically, there are a lot of problems with Roe, first of all. So the workability of Roe is difficult. When you put the standard at viability without really explaining why viability is the standard, you're kind of opening yourself up to attacks from future justices. Beyond that, if I could remember, my brain is a little fuzzy because it is the morning time for me. There were just so many problems. So first of all, history and tradition is something that's going to come up like over and over and over again with people that are originalists or with people that are talking about stare decisis, which is basically that you should be following precedent if you're in the Supreme Court. But stare decisis is like a coin, and on the other side of it, it talks about what kinds of cases would be egregious enough to where you wouldn't follow precedent over them. And a key factor there is workability. Is the decision workable in today's climate, whatever? And then beyond that, is the decision that you're reaching rooted in history and tradition, and whether you go with and or whether you go with or is really going to impact the way that you make your decisions, and or does it have something to do with the ordered liberty of the people or whatever? And so, you could look at history and tradition and use that to defend something like segregation in schools, right? That history and tradition would say that in the US, we would continue to segregate stuff. But in the interest of ordered liberty, we decided not to, right? So in that case, you would use an or. But in this case, with overturning Roe v. Wade, they used an and. They said it needs to be rooted in history and tradition and promote ordered liberty. And that interpretation Pisco turned us on to is going to make a big difference in the way that they look at stare decisis and the way they look at whether or not they should overthrow precedent. There were just a lot of little technical things. I would highly recommend that you just go back and rewatch it because I'm going to fuck up doing a TLDR of it. So they focus on that. Furthermore, with history and tradition, if you look back, it looks like a lot of states on the books had laws that were against abortions after quickening, and quickening is when the baby starts moving around in the womb. And so if 30-some states had laws on the books against abortion, it would seem that history and tradition was going against the ideas laid out in Roe v. Wade. And none of this was referenced in the justices' majority decision in Roe v. Wade or in Casey v. Planned Parenthood. And that kind of turning a blind eye to history and tradition is something that Alito beat these people over the head with in his majority opinion. He's talking about how, first of all, you didn't talk about the history and tradition at all, probably because it doesn't work out in your favor. Second of all, these two court cases seem like you're legislating from the bench. You're bringing in experts, you're laying out boundaries of where things start and stop without really explaining yourself. And then he goes through multiple paragraphs about how the process of arriving at the conclusions in Roe v. Wade, they seem to be legislating from the bench, which is not supposed to be the job of the Supreme Court justices. Related to that, Alito also believes that this is something that the state should be deciding, that what you're doing essentially is you're taking away from the American people the decision state by state to make their call on when they think abortion should or shouldn't be legal and what's going on there. And instead you made a decision for everybody, and then you enforced that for everybody in the country at a time when it was very clear that people were divided on the issue. Furthermore, there was a statement made, and I believe it was Roe, where they wanted to put an end to the discussion, that they said that through this decision, they will settle the issue of abortion. And Alito kind of hammered on that too and said, well, look where we are now. We're 50 years after this, and the issue is not decided. There is still a lot of vitriol between both sides and a heated debate over whether or not this should be okay. You failed to do that when you said that that was the purpose of the decision. And he picks out a lot of these little things and kind of, focuses on how a lot of the things that Roe set out to do, it was not successful in doing. And Casey v. Planned Parenthood after Roe had to outline more about what would and wouldn't be okay with limits on abortion. And then it proposed this undue burden standard, which again, when we go back to workability, it's not really workable, because even something like viability isn't workable. So for instance, hypothetically, let's say that at 24 weeks or something, the fetus would be viable, meaning that it could be taken care of outside of the womb or something like that. If you live in like Appalachia and you don't have access to clinics anywhere near you, and you don't have access to a good hospital with like cutting edge healthcare services, then what viability means for you as an individual there is different than somebody who maybe lives in Los Angeles, California, right? And so this viability standard is going to be different for different people in different places. And then you have to ask more questions about the undue burden standard as well, which is like, you can't put an undue burden on people who are looking to go get an abortion. Well, what is an undue burden? Because an undue burden, again, if we look at like the class divide between somebody who is poor, who works all the time, who doesn't have a lot of money to afford treatment and stuff like that, there might be a lot more things that are considered undue burdens for them than, say, somebody who has access to transportation, has a lot of free time, is able to travel, is able to afford treatment, right? And then we also have to look at where they live, right? If you live in a place that's very sparse and spread out, then is the distance basically this undue burden thing isn't really workable. And if you were to start legislating from the bench and you were to start getting like 50 different cases where you're constantly outlining where the lines in each of these cases is for undue burden, or where the line in each of these cases is for viability, and it's constantly changing over time with the developments in medicine or the developments in these different places in the United States, then it's not workable. You can't have the Supreme Court hearing cases every single year about abortion and constantly redefining the boundaries of abortion or of undue burden or of viability. If that's the case and that's what's happening, that sounds like a legislative issue. That sounds like something that each state and each community should be defining for themselves and should be figuring out on their own. And, that needs to be a standard that isn't set by the Supreme Court and is something that's worked out in every single state. Otherwise, the Supreme Court is going to be playing referee for every single abortion law that comes around. And that was another part of Alito's reasoning in giving the decision back to the states, because he doesn't want the Supreme Court hearing a gazillion cases about abortion because of the standards that they set that they're then going to have to referee and police. And they shouldn't have been setting those standards and putting themselves in the position of being a referee in the first place. That was like a legislative action that they took in like a legislative process, and that's not supposed to be their job. So that's kind of my like TLDR of what Alita was talking about. There's obviously a lot more there. We literally went through the entire thing. So if you're shouting at your monitor that I missed something, then I would highly encourage you to get the fuck out and go watch the other one. Obviously this is a TLDR and I'm operating off of like the top of my head with what I remember, but we literally go line by line through the entire thing. So if you're that kind of person, I would highly recommend that you just go check out the VOD. Couldn't you use that same logic against him when the majority support abortion? It's not so. There's so many problems with this statement that you've made that I don't know where to start with it, Dylan. So you could look at some poll that says that the majority of Americans support abortion, and I could show you that the majority of states have laws on the books or want to restrict access to abortion, right? And when we're talking about legislative issues, one matters a lot more than the other. So I don't think we should be like, I don't know. There's so much unproductive stuff in that one statement. Like, I don't like this idea of going into debate mode and using like Alito's logic against him or whatever. I really want to couch everything in terms of like talking about what he said, talking about what the other justices said. Thank you for that. Wow. Huge from Hiffer.
Have a great summer, Bookie DGGL.
Aw, thank you. I very much so appreciate that. With that donation, which was huge, thank you to Hiffer, we will bring on our guest for today. Drum roll, please. Inviting on to the show today, Pisco 95, resident lawyer and attorney. We're bringing him on to help us form some opinions about this, give us some definitions while we go through the document, and we'll see where he wants to start. Hey, what's up?
Smarts. How are you, my friend? Can you hear me?
Yes, I can. How are you?
Doing good, man. Doing so good. Just chilling on this fine Saturday. Is it Saturday morning where you are? Where are you?
I am in the UK.
Okay. So it's a little later.
Yeah, it's the afternoon Saturday.
Got it. Awesome. Well, thank you for having me. It's a pleasure as always to be on your show, and yeah, man, I thank you so much for the invite.
Yeah, I'm looking forward to it. Last time was fun, and I hope that we can keep the ball rolling with this one.
Me too. If I have any audio problems, because I'm not at the at my usual setup, and so forgive me if my quality is a little worse.
Okay, no worries. It sounds fine on my end, but I guess we'll see if people bitch about it.
Yeah, like they always do.
Yeah, like they always do.
All right, I'm ready to go whenever you are, man.
Okay.
What are we looking at?
So I'm not sure if you want to start with any opinion in particular, because I'm not sure how much time you have today.
I'm good to go for a couple hours. Yeah, I'm good wherever you want to start. That's that's perfect with me. If you think we've done the abortion and the death, we can do that. If you want to look at the dissents or anything like that, I'm happy to do that as well.
Okay, maybe we should start with the dissents. Which let's see, we got Kavanaugh concurring. We have Thomas concurring. Wow, Kavanaugh's is really long. We have Roberts concurring. Where do we have our dissent?
I think all the concurrences are super important. So
okay.
I wouldn't have a problem, because that's going to tell you where we're going to go next based on these statements in some ways. And so I would start with the Thomas concurrence.
Okay.
Have you looked at that already?
I have not. I just we had so much pro anti-abortion that I just wanted to have a taste breaker. But we could start with Thomas. Yeah,
sure. Why don't we go there, and let's also like take a little stock here for those of you guys who are anti-abortion or at least anti-Roe. about where we are, and what is, you got a flavor of the majority opinion last time and why they think it's such an easy question that Roe was wrongly decided, and such a easy question that stare decisis doesn't matter. In summary, the majority says, well, yeah, there may be fundamental implied rights, but abortion ain't one of them. The practice of abortion wasn't really thought of as being a fundamental right at the critical moment in history, at least for the majority's opinion. That's the mid 19th century, right around when the 14th Amendment is enacted. There's no analogy between abortion and these other fundamental rights like contraception and marriage and those recognized rights, because abortion involves a critical moral question of ending a potential human life, and none of the other implied fundamental rights cases do that. And the stare decisis factors in maintaining Roe and Casey, so says the majority, are slight, because we can't think about the reliance interest of people writ large, which is what a lot of abortion proponents rely on, is like it helps people in general think about themselves differently. They cite maybe some advances in technology, or sorry, advances in adoption procedures, and the fact that adoption is more widespread and it doesn't seem to be as big of an issue nowadays. There's ways to take care of your an unwanted child, and that the opinion was, quote, egregiously wrong, and that when you're talking about constitutional opinions on the Constitution, and when those are egregiously wrong, stare decisis is at its weakest. And so, given all of that, the majority says Roe v. Wade should be overturned. Now, I don't agree with how the majority is conducting its historical analysis. And you're going to get a flavor of the other position from the dissent today. But before we go there, because I'm not putting on my polemicist hat, I'm trying to be neutral. It's important to understand how the majority opinion differs from Clarence Thomas, who Booksmarts, I think, rightly characterized as being even a little bit more different than what the majority is like, and apparently so from the questioning.
He's out
there. That's what we're going to get into right now, I think.
And one thing that might be important for this is substantive when it comes to your rights, or something like that, because I think he doesn't believe that there are substantive rights with the Fourth Amendment.
Yeah. So let's talk about that. Can you hear me, by the way? I think I cut out for a second. Okay.
No, you're good.
Okay. What is this due process clause? There are two due process clauses in the Constitution, in the amendments of the Constitution, the Fifth Amendment and the 14th Amendment. And pretty much they say, with respect to the Fifth Amendment as applied to the federal government, the federal government shall not deprive you of life, liberty, or property without due process of law. And the 14th Amendment says the same thing with the states. The states shall not deprive individuals, persons, right? People. That's important. Persons. Doesn't say cats. Doesn't say objects. It says persons. Of due process of law with respect to life, liberty, or property. Those are the constitutional basis for a lot of procedural protections in this country. You know, you're not allowed to just be like, the government sues you for violating some civil statute. You don't get any right to call witnesses. You don't get any right to do anything, and they just take your money, like, bye. That's not how this the due process clause has been understood before. Certain procedural protections to individuals when they're involved with government deprivations. This has been applied, for instance, to Social Security payments, that when a government decides to take away your Social Security, they can't just, even though they don't have to give you Social Security, right, Boogie? They don't have to give you Security in the first instance. They weren't required to pass a Social Security law that gives you access to benefits, whether, like, if you're disabled or something like that.
Sure.
But if they're going to take it away from you, certain things, they need to give you procedures. And that applies to, your property, certainly your life, right? You can't just be charged with a crime of murder and just like, okay, you're guilty, bye. That's not due process, right? You have to have real procedural rights there. That's the procedural component to the due process clause. And as I said, the 5th and 14th Amendment applies that both to the federal government, the 5th, and the 14th to the states. There's another concept of the due process clause that has been developed called substantive due process. That idea is that by saying that the due process clause protects liberty, right? Without due process, what does that liberty thing mean? That it's implying that there's by saying that we're protecting these things with procedure, you're implying that there is some fundamental liberty there. And does that kind of logically follow? You're saying that you can't be deprived of life, liberty, or property without due process of law. The implication is that there's some liberty interest there to protect. Because it probably doesn't just mean your physical freedom. That's one way to interpret that liberty there. It just means your physical freedom. But our courts have understood that liberty there implied is that there's some other things that constitute what liberty is. That combined with the 9th Amendment, which says that the enumeration of certain rights in the Bill of Rights shall not be used to disparage other rights which may exist. Kind of implies that there's some exercise that the courts are. This is the position of people who think that substantive due process is a good idea, but they take that as there's some exercise that the courts are supposed to do, which is finding implied fundamental rights. Maybe you think that the implied liberty in the due process clause relates to the rights that are explicitly enumerated in the Constitution. That's the Bill of Rights. You could have that opinion, right? That's the basis of the incorporation doctrine, whereby the Bill of Rights, which only applied to the federal government, will now apply to the state governments because of the implied liberty of, due process of law. That combined with the 9th Amendment, which is talking about unenumerated rights, leads people to think that there are certain rights that the court should be entrusted in finding, the fundamental rights, which state governments and federal governments cannot transgress. And so that is the doctrine of substantive due process, and the doctrine of substantive due process with respect to unenumerated rights. That there's an implied substantive component to what liberty is besides just the procedural protections, and that's implied by the due process clause. To put a finer point to that, just for a moment, if you're a non-citizen in this country, you have no right to stay in this country, right? Except the right which Congress has granted you, or the federal government has granted you to stay in this country. But the federal government can take away your right to be, if it wanted to tomorrow, the federal government could get rid of all green cards and say you all have to leave the country. It could do that legally. That's where our precedent says. You might be given some procedural protections to be like, I want to prove that I'm an American citizen, and so I'm not subject to deportation. So you can't just pick me up and leave me and deport me. I have to be given at least the opportunity to show that I'm an American citizen, or that for whatever reason you can't deport me right now. That's the procedural protections. The substantive component would be something like, no, you have a right to stay here, like a right to stay in this country. This is not a great analogy in the sense that no one is talking with the substantive due process with the right of like immigrants, but it's just to show you the divide between procedure and substance. That procedure just says, I have a right to certain things, right to cross-examine witnesses, right to present my own evidence, right to opportunity to be heard, notice. Those are the kind of things that procedure protects. Substance protects the thing there. Your right to stay in the country, your right to get benefits, not just your right to have procedures. There, and I've gone on enough on that, but it is a contentious doctrine, and some people don't agree with it. Clarence Thomas is one of those people.
Gotcha. I'm always hesitant with what feel like get out of jail free cards to make shit up for the court, and this is kind of feeling like one of those. Like, we're going to look at this in a very particular way so that we can use a vague word that doesn't have a good definition to kind of fill in the blank with whatever we feel like people should or shouldn't be allowed to do. And that, you know, while it could provide us like good rights, I feel like at the same time, it just seems to let them do whatever they want.
You can take that opinion for sure. But I'll give you two counters to it. Not that these are my counters, but that these are the counters that exist. One is, if you take the historical approach, what was the 14th Amendment trying to do? The 14th Amendment was trying to put states on equal footing with the federal government with respect to rights and who's allowed to violate them. We just had a civil war, and what was happening in the wake of the Civil War were like black people and racial minorities were being targeted by the southern states for bad treatment, and there was no assurances that these people were going to be treated like actual citizens. And so what the 14th Amendment was getting at was trying to have states protect and recognize that other groups have rights too. To that end, it kind of makes sense that you would apply the Bill of Rights to that end to the states. Otherwise, what kind of liberty would the due process clause be protecting? If maybe not the unenumerated rights, but at least the enumerated rights with respect to the federal government. Surely, if you're going to say that there's something to protect, why would you need procedures to protect something that you don't have a right to?
Yeah.
And so, does that make sense?
I guess, yeah, I should be more specific. Like, what I'm concerned about is when we make things up that don't exist. So like, if you're using this substantive argument to look at the Bill of Rights and apply those, I think that's fine. You know, that makes a lot of sense. But then if you're using that to come up with rights, and then you use that as your foot in the door to get in like political rights that don't exist or can't even reasonably be read from the other amendments, then I would have a problem with that.
I will. The only thing I'll say, that's the second thing I was going to say is, I guess second and third thing. The second thing is the Ninth Amendment is one of the textual bases for finding unenumerated rights. But the Ninth Amendment just says do not disparage. It doesn't necessarily say that the courts are the ones who are supposed to find those other rights that exist. Some people think of the Ninth Amendment as a rule of construction. Others think, as I do, that it seems to anticipate that courts are going to have some responsibility here in finding those unenumerated rights. And although you're right, it doesn't explicitly say that. It's a doctrine that you need to do a lot of interpreting on the front end, and when I say interpreting, people will say making shit up, but I don't think that's what it is. But you do have to have a law review article to discuss why this is okay, and you need to have some foundation to discuss it and to talk or to back it up. And people, when they first hear it, are gonna sort of toss it to the side or think that it's pure bullshit or make believe. But the other thing to recognize here is that everybody's doing it. Everyone is doing it, down to Clarence Thomas. Even though he doesn't believe in the due process clause part of it, we'll get into where he draws his unenumerated rights. But let me give you an example. If the court were to say something like, it is a crime to get married in this country, this court, including the conservatives, are going to step in and say that that's unconstitutional. But the Constitution doesn't talk about marriage, right?
No.
Constitution doesn't say you have a right to marriage. That's not one part of the Bill of Rights. But the conservatives are going to recognize that there are some things that are so fundamental that you can't transgress them, that there are implied fundamental rights. Everyone in the court seems to suggest that that's the case. And so they just disagree on what those implied fundamental rights are. So you might think conceptually there's no basis to do that, but you have to deal with the practical reality that every one of the court's members I believe, and I think that this is, if you give any of these hypos, they would agree with them, would find implied fundamental rights somewhere. And so to the extent that you're mad at people for doing this implied fundamental rights thing, in order to be mad at them, you have to be mad at the entire court, including Clarence Thomas and the conservatives. Mm-hmm. And also you have to bite the bullet on some really uncomfortable hypos, which is like the state is allowed to take your children away, or the state is allowed to force you to be pregnant. Well, those are right.
Like when I'm thinking about this in my head, I think that the rights, I'm thinking about the history and tradition thing a little bit. Like, I think that rights are afforded to you by the collective decisions of state governments. So if state governments begin to create an architecture around the concept of marriage, and they give you a bunch of rights regarding marriage, like spousal rights, or if we have things about childcare and what you're able to do as a parent, then they're creating. I think that it's fine when it is the states creating those, whether that's through amendments and ratifying those, or through like local laws that they're creating that begin to outline these. But I think they are the entity that can pull from the darkness of nothingness these kinds of rights. And then as they collectively start to paint that picture, then that's the canvas on which the Supreme Court can comment on. What I'm uncomfortable with is the court reaching into that darkness of no existence of rights and pulling something from it that isn't rooted in anything that the states came up with. And that would be where I have problems, is I think they have to use what's existing already in law and then use that to define why they think there's a right there, as opposed to just making it up on their own.
Yeah, I think you can take that opinion. But I'm just giving you the notion that to really believe that and to be ardent about that, you're going to disagree with the conservative majority in the Supreme Court. And that you could be like, that's fine, I disagree with them. You're going to disagree with them on some issues, and you're going to have to bite the bullet and be like, yeah, it's constitutional for the government to force women to get pregnant, right? Let's dwell on that hypothetical just for a second, right? Why would it be unconstitutional for the government to be like, all 20-year-olds have to be pregnant and we're going to impregnate them?
Well, that would stomp on their liberty, no?
Wait, but where in the Constitution does it say that you have a right to be free from government pregnancy factories?
Well, I mean, if Florida randomly started doing that and no other state had ever done it before, I think like every other state going the other direction would seem to be creating a right there to make your own decisions about child rearing.
I love you, because that is an exercise in finding an implied right. What you're doing there, it's not in the Bill of Rights, and you're doing exactly what the court would probably do with its analysis. It's like, has this ever happened before? Is the right to rear your children and the decision to have a child, is that fundamental?
Hey, Book, don't forget to hydrate during these warm times.
And you're doing the exercise of implied rights. You just, when I give you the example of forced pregnancy, oftentimes conservatives be like, that's not fair, that'll never happen. Like, I'm just doing an exercise here to be like, would that law be constitutional? And the answer is, there's not a single vote on the Supreme Court would say that that's constitutional. They would all say it's unconstitutional. And you would probably say it's unconstitutional too if you were in that position. The reason, even though that there's no textual basis for saying that the state is not allowed to do that, right? The state's not going to, by making you pregnant, the state is not, let's say they give you all the procedures in the world. You have the procedures to be like, I'm not 20 years old. They give you all the procedural rights you want. The state's not killing you. They're not depriving you of life.
It feels like a Fourth Amendment issue, but this is a crazy hypothetical.
The Fourth Amendment, an unreasonable search or seizure, that deals with more like police interaction. But even assuming this was a seizure for constitutional purposes,
they're like seizing her womb and like using it, or even like a
reasonable search, right? Under the law, it would be defined as reasonable seizure, right? A defined reasonable seizure, because you don't have, let's say they're all court ordered, right? A seizure, all it is for it to be unreasonable. Typically, that's like where there's no warrant or there's no judicial oversight. but a court stamps it and says, yep, you are 20. Yes, you have to follow the law. And so you need a substantive basis under which to challenge the law, not just a procedural one, and not just the Fourth Amendment one where the only question is about reasonableness. That reasonableness isn't like this elastic thing that can make rights out of nowhere.
Okay, but I will put a pause on this because I think we should jump into the opinions.
But just to get you, just to get you a sense of like the bullets that you might have to bite if you think that there's no implied rights. And even as you were answering that question, it seemed like you were willing to go to history and tradition and all that stuff to try to invalidate the law, which I think is the right thing to do. And I think that's what this court would do, and anybody on this court would do.
Okay. So starting with Justice Thomas. So we have Justice Thomas concurring. I join the opinion of the court because it correctly holds that there is no constitutional right to abortion. Respondents invoke one source for that right. The 14th Amendment's guarantee that no state shall, quote, deprive any person of life, liberty, or property without the due process of law. The court well explains why, under our substantive due process precedents, the purported right to abortion is not a form of liberty protected by the Due Process Clause. Such a right is neither deeply rooted in this nation's history and tradition, nor implicit in the concept of ordered liberty.
So look what he says. It's neither deeply rooted nor implicit. Not and implicit. He could have just said such a right is not deeply rooted and implicit, but he said neither deeply rooted nor implicit. Remember when we were talking about the or and distinction on the Glucksberg test and analysis?
Yes.
Here it seems like Justice Thomas is recognizing it's not just deeply rooted, it's implicit in the concept of ordered liberty. This is a bifurcated test.
Mm-hmm.
So that's the only thing I'll say is that this distinction might seem slight to you or to watchers, but having the and operative there seems to suggest, in the majority opinion, that it's not enough for it to be implicit in the concept of ordered liberty for it to be a right. But here, Thomas, the way he says it, seems to suggest, not necessarily, because he could just be saying that it fails both parts of the test, right? He could just be saying that neither part of the necessary components of the deeply rooted tests are met here, but at least there's some possibility here that Justice Thomas agrees that it's a bifurcated test and that if it's implicit in the concept of ordered liberty, it's enough. Okay. He doesn't discount that possibility.
Right. Quote, the idea that the framers of the 14th Amendment understood the Due Process Clause to protect a right to abortion is farcical. I write separately to emphasize a second, more fundamental reason why there is no abortion guarantee lurking in the Due Process Clause. Considerable historical evidence indicates that due process of law merely required executive and judicial actors to comply with legislative enactments and the common law when depriving a person of life, liberty, or property. So this is beginning that there is no substantive, right?
Component.
Yeah.
Yep.
Other sources.
Just real quick. Yes, he's saying that due process of law is just about procedure. And this has been Clarence Thomas' opinion and a Scalia opinion for a while now. He's still going to say that there's implied fundamental rights. But he says that this substantive due process stuff, at least he's heavily implying it. That's why he says considerable historical evidence indicates that this was merely about making people comport with certain procedures.
Okay.
Yeah.
And quick question from the chat. What is an example of when that test has been bifurcated, that or and?
I would say it's not been typically, I think my perception has been that when you're accepting these fundamental rights, the court will say that you meet both tests, right? This is deeply rooted and implicit in ordered liberty. And also the courts the majorities for some of these substantive due process rights post Roe have been not very clear about the formalism behind the test. There have been opinions by like Anthony Kennedy, who sometimes his opinions can be like unclear. And so I don't know that you have a good example of the court being like, step 1, deeply rooted. Step 2, implicit in ordered liberty. I don't think the court has formalized that. That's just my observation on a way you could view that test. Either because you have both of those phrases there, right? Both of those phrases come from somewhere. Deeply rooted in history and tradition and implicit in the concept of ordered liberty. Formally, like, there should be some way to reconcile how you're supposed to view those two phrases. Are you supposed to view them together and in concert, or as separate things? And technically there should be an answer for that. And so if it came down to it, are they just repeating the same thing? Is it redundant? Is saying deeply rooted in history and tradition the same thing as saying implicit in ordered liberty? If so, why would you have to say both things? And if you don't have to say both things, then why would you just say deeply rooted in history and tradition? But they say both, you know? And so the fact that they say both suggests that they're different kind of things. Now, the only question left is, are they different in that you could do one or the other, or are they different in that you need to meet both? But from my reckoning, even though the court might not have like formally addressed that, and there's no good example of them taking that step 1, step 2 analysis, it's a question that needs an answer, and it's outstanding, you know?
And it hasn't been answered ever in any other case. They've never like debated this idea of whether it's an and or an or.
What you have is language, right? You have justices using or and as I understand it, I don't think that there's a court case where being like, this is a 2-part test and this is what you do. And step 1 is deeply rooted and step 2, like what you'll have is the courts being like, this is obviously a right. It's deeply rooted because we think of the right not as the right to abortion, but as a right to bear or beget a child. And that right is deeply rooted in history and tradition. And what do you know? It's also implicit in the concept of ordered liberty. But they won't say it like that. But it's just me calling it out because it's a conceptual thing that needs a resolution. Otherwise, this process of substantive due process, or implied fundamental rights, that's a difficult one to see, like, what the approach is going to be of the court going forward. And it seems like the court, I'll say this, it seems like the court doesn't do the implicit and ordered liberty analysis, whatever that is. It's only looking at history when it's looking at abortion, right? Mm-hmm. It's not being like, this is so important, this is necessary. It's not looking at the kind of things that you might hope from an implicit and ordered liberty analysis. And so at least in function, it appears that you need the history. As far as this court's majority is concerned, if you don't have the history, you lose. Do you also need the implicit and ordered liberty part? Maybe, but the court doesn't spend any time talking about it and only talks about the history. So it seems like the history is the most important part.
Okay. So continuing here, others, by contrast, suggest the due process of law prohibited legislatures from authorizing the What?
Oh, sorry. There was my bad. Go ahead.
No worries. Prohibited legislatures from authorizing the deprivation of a person's life, liberty, or property without providing him the customary procedures to which freemen were entitled by the old law of England. Either way, the Due Process Clause at most guarantees process. It does not, as the court's substantive due process cases suppose, forbid the government to infringe certain fundamental liberty interests at all, no matter what process is provided. As I have previously explained, substantive due process is an oxymoron that lacks any basis in the Constitution. The notion that a constitutional provision that guarantees only process before a person is deprived of life, liberty, or property could define the substance of those rights strains credulity for even the most casual user of words.
He's citing to himself, right? All his concurrences, and I guess also Scalia at the end there.
Yeah, he's like throwing me off with that. The resolution of this case is thus straightforward. Because the Due Process Clause does not secure any substantive rights, it does not secure a right to abortion. The court today declines to disturb substantive due process jurisprudence generally, or the doctrine's application in other specific contexts. Cases like Griswold v. Connecticut the right of married persons to obtain contraceptives, or Lawrence v. Texas, the right to engage in private consensual sex acts, and Obergefell v. Hodges, the right to same-sex marriage, are not at issue. The court's abortion cases are unique, and no party has asked us to decide whether our entire 14th Amendment jurisprudence must be preserved or revised. Thus, I agree that nothing in the court's opinion should be understood to cast doubt on precedents that do not concern abortion. For that reason, in future cases, we should...
Sure. So, what Clarence Thomas is saying directly is he doesn't believe in substantive due process. And the logical extension of that book is clear. If you don't believe in substantive due process, all these other cases about marriage and gay sex and contraception, those have to go away. That's just logic, right? If you don't agree with the doctrine that gives you something, those cases have to be overturned. Or at least those cases are wrongly decided. Maybe you think for whatever reason stare decisis matters for Lawrence, Obergefell, and for Griswold, but there's no real indication that this court would be like, oh, Roe v. Wade egregiously wrong, but gay marriage not egregiously wrong, at least in terms of the logic of the opinions. And so this is me kind of putting my analyst hat on, but it seems to follow logically. Unless you agree that courts should be doing implied fundamental rights under the due process clause, you must think that all these cases were wrongly decided.
I don't think it's that simple. They're all very, very different for very different reasons. And I don't feel like it's as simple as like, oh, well, you don't believe there are substantive rights, therefore all these things will be taken away. There are history and tradition arguments. There are arguments based on where the states were at with their legislation, like in Obergefell, looking at today, from the early 70s when there was that very first case in Minnesota all the way up until now, things changed, and that was part of the influence on the decision. So, I mean, like, I think that it's not as clear cut that they would necessarily rule one way or the other because of one interpretation.
Bookie, I'm not saying that they would rule one way or the other. I think it's quite likely this court would not overturn Griswold. Mm-hmm. And so I'm not saying that because of, we'll see Kavanaugh's concurrence among other things. I'm not saying that these rights are going to go away in 5 years. What I'm saying is logically, if you follow Clarence Thomas's line, that substantive due process is bullshit, and that this implied rights, at least with respect to the due process clause, maybe these cases still come out the same way because of the equal protection clause, right? Yeah. Maybe these cases still come out of the way because of the privileges or immunities clause, but at least with the substantive due process holdings of these cases, they go away because they rely on substantive due process. How can you say that we don't agree with substantive due process, but the cases that rely on substantive due process are still cases that were decided correctly? That's impossible logically. Now, you could be right that this court is not abandoning substantive due process, and therefore, because they're not abandoning substantive due process and because they're saying that abortion is different, this court is not going to overturn those rights, and they're not taking Clarence Thomas's position. But I'm just saying, formally speaking, if you're taking Clarence Thomas's position, which is that this is all bullshit, those cases which rely on that same logic are just as wrongly decided as abortion. Or at least in the same way.
If it was the case that they entirely hinged on that, I would agree. But in the one that we've done enough reading on that I can kind of understand it, Obergefell, like, it relied on much more than just substantive rights. Like we were talking about like procedural rights when we're talking about giving equal protection to both groups of people, both same-sex couples and regular couples, that if the states are going to create these rights surrounding marriage, they don't have a good reason to give those rights to heterosexual couples, but not give that to homosexual couples. That didn't make sense. They're not being given the same rights. And I see other arguments being used in the majority opinion for that, and they don't seem to all just rely on substantive rights.
They can. That's why I made the carve out and saying, like, maybe you just construe Obergefell as an equal protection case.
Mm-hmm.
I have my own doubts about why this court would not do that. But you could do that. But at least the substantive due process component, saying that marriage is fundamental under the due process clause, saying all that shit,
mm-hmm.
that goes away. You know, that all that stuff, that marriage is fundamental, that you have a right to it based on the due process clause, that goes away. And if you have a right that entirely depends on the due process clause, like contraception is, right? Contraception, there are equal protection cases for contraception, but that's just like applying laws differently between groups. But let's say there was no different application. You say for everybody, contraception is illegal. You don't have an equal protection violation because you're not treating different groups that are deserving of scrutiny differently, right? You're not treating any group differently. Everyone is not allowed to use contraception. There's no exceptions.
Yeah, I'm not educated on the contraceptives case, but if that is the way that it was put forward, then yeah, for the contraceptive case, I think that would be a problem. That if you just applied it to everybody, then you can avoid issues with being applied equally. Although it says right of married persons to it, I don't know, but I haven't read it, so I don't.
That's because Griswold is specifically about married people, and then the equal protection part of a case called Eisenstadt. So there was a case involving married people. That's Griswold.
Mm-hmm.
And there was a lot of language in Griswold about the privacy of the marital bedroom, all that stuff. And a later on case called Eisenstadt, where there was a law that wasn't for married people, it was for unmarried people. And there the court engages in equal protection analysis. But it's kind of, nowadays we would see the issue as largely a substantive due process one, not an equal protection one. That's a little bit out of sync with how we view the equal protection clause nowadays.
Gotcha.
Yeah.
So continue.
Next paragraph is a big paragraph.
Okay, so we're on the next paragraph?
Yeah.
Okay. For that reason, in future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell, because any substantive due process decision is demonstrably erroneous. We have a duty to correct the error established in those precedents. After overruling these demonstrably erroneous decisions, the question would remain whether other constitutional provisions guarantee the myriad rights that our substantive due process cases have generated. For example, we could consider whether any of the rights announced in this court's substantive due process cases are privileges or immunities of citizens of the United States protected by the 14th Amendment. To answer that question, we would need to decide important antecedent questions, including whether the Privileges or Immunities Clause protects any rights that are not enumerated in the Constitution, and, if so, how to identify those rights. That said, even if the clause does protect unenumerated rights, the court conclusively demonstrates that abortion is not one of them under any plausible interpretive approach.
Pause.
Sure.
So this paragraph tells you a couple things. One, that Clarence Thomas, and this is not me being political, Clarence Thomas wants to overrule all the substantive due process holdings of those other cases and thereby overturn those cases. He calls them erroneous decisions. So at least from Clarence Thomas's perspective, those cases were wrongly decided and must be overruled. However, he's leaving to another day about whether or not the holdings, the specific holdings in those cases, can be found to be protected by other parts of the Constitution. And he points to the Privileges or Immunities Clause of the 14th Amendment. that's a clause that says that, you know, states can't deprive citizens, U.S. citizens. It doesn't say persons, right? Due process clause says persons.
Mm-hmm.
This would only apply to citizens, right? And not everyone in this country is a citizen. But just to be clear, so at most, if let's say that you said, okay, everything under the substantive due process holdings of this court is protected under the privileges or immunities clause, you are saying by having to be under the privileges or immunities clause, it only applies to U.S. citizens.
Mm-hmm.
And so that would mean like non-citizens have no gun rights. Non-citizens have no, you know, to the extent that there's a First Amendment right, non-citizens have no First Amendment rights with respect to state governments, only as applied to the First Amendment.
Mm-hmm.
Only applied to the federal government, but non-citizens, like if a state wanted to ban a non-citizen from speaking in their territory, you would have no right to be like, they're not allowed to do that. So states could freely ban speech from non-citizens. And then he also goes on and says he's not deciding whether the privileges or immunities clause will protect implied fundamental rights, but it could.
Mm-hmm.
It could. And my suspicion is that if push came to shove, he would respect some implied fundamental rights.
Gotcha. And
Right.
in regarding the First Amendment and free speech, we do explicitly restrict the freedom of speech of non-nationals, right? Like, or non-citizens.
In many ways, yeah. In many ways, yeah. The country has, like, obviously foreign donation bans and, like, foreign speech bans and all that shit with respect to people who are outside of the country. And being a unregistered like lobbyist for a foreign government, those are kind of things that probably would, or at least questionable constitutionality if it were applied domestically. So certainly I would say that the First Amendment has less power with respect to non-citizens in many cases, but they've stopped short of saying non-citizens have no First Amendment rights, you know?
Right.
With respect to this, right? It says Congress shall make no law abridging the freedom of speech. And okay, Congress is allowed to do some stuff to protect its sovereignty with all these foreign governments trying to like meddle. But does that mean that non-citizens have no speech rights? Does that mean that non-citizens can be arrested for protesting, you know, by the federal government or by state governments? That, you know, that I think that's a pretty radical perspective. And I think most people would think that, okay, non-citizens, when they're in the country, when they're protesting and stuff, and they're not like necessarily just funding stuff, okay, at least they can't just be arrested for what they say.
Right.
You know, if you take the other approach that like non-citizens have no speech rights, then you should have no problem with like Julian Assange being in prison, right? There's no basis to say like you have any First Amendment rights at all if you're a foreign journalist. And I think people are uncomfortable with that.
Yeah. Uncomfortable, although it sounds like they don't have these things like written out to protect them, which is kind of even scarier.
Although all the First Amendment says is Congress shall make no law abridging the freedom of speech or the press, right? That's all it says. It says what the freedom of speech is. That's one of the problems with people who are like, I don't like things that are not explicit in the Constitution. Like, what the hell does the First Amendment just says free speech. In order to get to where we're going with all of our First Amendment jurisprudence, it's like bans child pornography is okay. It's okay to ban like obscenity. It's okay to ban like threats and defamation and that kind of stuff. You have to do a lot of interpretive work. The First Amendment doesn't explain itself. There's like a ton of stuff that requires, even for explicitly enumerated rights, who cares that it's explicitly enumerated? What we care about is the scope and how it's going to affect our lives. And so, yeah, there's something called the freedom of speech, but in order to discover that, we need to do the kinds of things that we would do in substantive due process analysis. Well, what did the framers think the First Amendment meant? Did the framers think that they were getting rid of all defamation law? No. Did the framers think that they were like preventing states from banning child pornography to the extent that it even existed back in the 18th century? No, probably not. So like,
But
even go ahead.
I think when it comes to like, do foreign nationals have the right to the freedom of speech? It would seem like in the preamble of the Declaration of Independence, they seem to indicate, the framers at least, that like all men would be able to have those rights. So maybe that would solve that question about foreign nationals.
But the Declaration of Independence has been held by this court is not law.
No, not law, but if you're looking for like, how did the founders or the framers interpret these things as they were writing them down, that might be a good indication of that.
Maybe, but John Adams, one of his first acts, or one of his most famous acts as president, was to like pass the Alien and Sedition Act, which was pretty much, it's a federal crime to criticize me, and anyone I don't like and who says something bad about me, I can deport. That's John Adams, and these people talk endlessly about the potential corruption from England, potential corruption from France. You have people who the Anglophiles and the Francophiles, and so these people were no friends to foreign influence in the internal affairs of the United States. A lot of the Federalist Papers are like, how are we supposed to prevent that? How do we prevent governments from getting our states all riled up and joining a faction, or getting like an alliance of states to support England or something? And so, yeah, they have this thing about in the Declaration of Independence that all men are created equal, but that's never been really what our country has understood. Either with like immigration, like if all people were created equally, why are immigration laws constitutional? And everyone kind of agrees that they are, and so clearly people are unequal. There's a difference between a citizen and a non-citizen. And the government treats them differently. Doesn't let non-citizens necessarily stay in this country.
I guess when I was pointing to that, I was looking a little bit farther from that they are endowed by their creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, and that to secure these rights, governments are instituted among men, deriving their powers from the consent of the government. Like, I think that would seem to point in the direction that the point of the government is to protect like the basic unalienable rights, and among those would probably be the ones in the first 10 amendments.
Potentially, yeah.
Anywho,
let's move on. We're far afield, but it's interesting.
Where did we leave off at?
Where are we? Yeah, moreover.
Okay. Why do I not see where the fuck that is?
Second paragraph, page 4 of the concurrence. Top left gives you the page.
Gotcha. Moreover, apart from being a demonstrably incorrect reading of the Due Process Clause, the legal fiction of the substantive due process is particularly dangerous. At least 3 dangers favor jettisoning the doctrine entirely. First, substantive due process exalts judges at the expense of the people from whom they derive their authority. Because the Due Process Clause speaks only to process, the court has long struggled to define what substantive rights it protects. In practice, the court's approach for identifying those fundamental rights unquestionably involves policymaking rather than neutral legal analysis. The court defines new rights in line with its own extra-constitutional value preferences and nullifies state laws that do not align with judicially created guarantees. Nowhere in this exaltation of judicial policymaking clearer than this court's abortion jurisprudence. In Roe v. Wade, the court divined a right to abortion because it felt that the 14th Amendment's concept of personal liberty included a right of privacy that is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. In Planned Parenthood of Southeastern Pennsylvania versus Casey, the court likewise identified an abortion guarantee in the liberty protected by the 14th Amendment. But rather than a right of privacy, it invoked an ethereal right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life.
He's quote hunting Just to be clear, like he's quote hunting a little bit here, and the case does not abandon the right of privacy rationale. It gives multiple rationales, but these are good quotes for his position. So like, but he's a little bit quote hunting, and he's presenting his own narrative. Just be aware of that.
Gotcha. And I wonder if he was the one that contributed this quote to the majority as well. This meaning, universe, mystery of human life.
Oh no, he did not contribute that. He was in dissent in Casey.
Oh no. Okay. So this is coming from Casey then. Gotcha.
Yeah, it means IBID. If you've ever used IBID, it's like whatever the previous source was.
Gotcha. Yeah. As the court's preferred manifestation of liberty change, so too did the test used to protect it, as Roe's author lamented. The Roe framework is far more administrable and far less manipulable than the undue burden standard.
He's saying like, look, these hippies disagree with each other. But you can say the same thing about originalists. Like originalists, you all disagree with each other. He's essentially, his argument is this is so dangerous because we can't agree on what's what. The rationale changes and the rule changes, right? The rationale, is it right to privacy, or is it right to define one's own concept of existence, of meaning, of the universe, of the mystery of human life? Which is it, bro? And like, even if we agree on which it is, you guys disagree on like, what is the rule of law? Is it the Roe standard or is it the Casey standard? Look at you. You guys are like adding each other on Twitter and you guys can't even agree with each other. That's why this is so dangerous. Does that make sense as an argument? Like,
yeah,
the fact that you guys can't even apply this in a consistent way and you can't even come to a consistent rule of law shows you that this is dangerous.
And it's all based on your feelings, and that's part of why it's changing, is because you have this, you have a lot of leeway with interpreting things. And
yeah, he says felt because I have to put on my polemicist that this is a little bit dishonest. The felt quote is from picking between either the 14th Amendment or the 9th Amendment for where the right to abortion comes from. And in Roe, they're like, whether or not you think that it comes from the 14th Amendment, as we feel it does, or the 9th Amendment. And so like in that context, he's not saying like our fifis are the 14th Amendment that says that. It's just showing a preference that it's the 14th Amendment that's driving the analysis and not the 9th Amendment. And so like, I don't necessarily think that this is like, oh, the court admitting that it's doing feelings and fifis. But when they said felt, it's a really like, how is Clarence Thomas not going to use that quote,
Yeah. And as a tip to anybody, and this applies to essays as well, like if we look at the structure of that, of the way he's using quotes here, like we have a 4-part quote. We have a single word in this quote, and it had to be changed from the context in which it was used and separated from the rest of the quote. Like there's a lot of work being done here to be able to use these quotes in the way that he's using it and to have the feeling that he's trying to put forward. And like anytime that's happening, you should probably have a bit of like a yellow flag in your brain with how the quote is being used, whether it's in an article for a journal or, something that you're reading on some website, or in the case here, the way that he's using this quote in his opinion. I think it's suspect.
It's so true, man. It's so true. Lawyers will do this all the time, is they'll take disjointed quotes that in context kind of give a different quote feeling and make it seem as though it's like one thought. And really they're just like, you're just picking words and putting them together. This is not so egregious that I would say he's misrepresenting. I don't think he's misrepresenting here, but in the sense that he's like lying or doing anything like that. But it is definitely a stylistic choice, and one that you should always verify. So I totally agree with what you just said.
Gotcha. Now, in this case, the nature of purported liberty supporting the abortion right has shifted yet again. Respondents and the United States propose no fewer than 3 different interests that supposedly spring from the Due Process Clause. They include bodily integrity, personal autonomy in matters of family, medical care, and faith, and women's equal citizenship. Jesus, this is so hard to read. Wait, where do I start again? That 50 years have passed, right?
So he says, yeah, the 50 years have passed since Roe, and abortion advocates still cannot coherently articulate the right or rights at stake, proves the obvious. So he's saying like that 50 years have passed since abortion, and they can't coherently. So this, remember, you were really confused about why Thomas was asking this question back in your original stream where we were like, where I was chatting and responding to you. Mm-hmm. You were like, why is Thomas asking like the interest question? And I said, he's basically telling the government, like, you have to choose one of these interests. Is it about bodily autonomy? Like, is it like about privacy? Is it about personal autonomy in matters of family, medical care, and faith? Is it about the equal protection stuff? And Thomas in that moment was pretty much saying, you have to choose one. And the fact that you're saying like, oh, well, it's all of them. It's any of them. That's what he was getting at with his questioning there. He was being like, you're not being, you knew that he was setting up for a line here where he was going to say, they can't decide. And so they're just going for broke and they're picking any one of them and hoping one of them sticks. That was his point in the oral argument. That's his point now.
Gotcha. Part of me also wondered if like one of the possible answers they could have given is that like it's about the debatability of whether or not that's a life. That like if we pick viability as the point where you consider it life, then it's also the point at which the state can take an interest in protecting the fetus from the mother. But I don't see that repeated anywhere. So I wonder if that's like a misinterpretation on my part.
That's a that's the argument. The when does life actually begin argument, that's the argument that's even like too radical for Thomas to say out loud. All right, so follow me here. The Constitution protects persons, right? Mm-hmm. It protects other groups too. But at least in terms of like due process and equal protection, Constitution protects persons. And if the Supreme Court held that at conception you are a person, that means that all conceived embryos, all fetuses, have constitutional rights. And there's I think a decent argument that if you have constitutional rights as a child, as an unborn child, and you're entitled to equal protection under the law as an unborn child, that not allowing your your murder laws to extend to unborn children would be an equal protection violation.
Right.
Right. So if you're a person when you're conceived, why are states allowed to not characterize abortion as
murder?
As murder? Why are they allowed to not characterize it that way? That would, in another sense, constitutionalize anti-abortion, pro-life, right?
Yeah, and I just remembered one other thing, and this is why I thought this, is he brought up, I believe, a case where this woman got in trouble for, I think it was like taking drugs or something and then miscarrying. And she got in trouble for that because like her taking drugs and whatever had led to the miscarriage. It was something like that, right? They brought up in oral arguments. Oh, we may have. Oh, we lost you for a second there, Peace.
Hello. I'm sorry, my internet's being a little dodgy.
You're good.
That shows that there's that states had an interest in protecting unborn life. Yeah. Right. And that states had laws that criminalized at least a kind of abortion, maybe an unintended abortion. So that plays into the history argument, but it also potentially is some support that maybe states consider unborn children to be persons. Mm-hmm. And you could see that playing into an argument about why personhood starts at conception, or at least starts at some level of not being born. And again, to state that argument, I think there's a significantly compelling argument that if you are a person under the Constitution when you're unborn, it would be an equal protection violation, potentially, right? This is just an argument. I'm not saying it's a necessary conclusion. The argument would be to not extend the murder laws to cover unborn persons would be an equal protection violation. It would be like, are states allowed to say it's only illegal to murder people up to the age of 40, but it's not illegal to murder 60-year-olds and 70-year-olds? Like, is that constitutional for a state to be like, you're allowed, we have murder laws, but they only apply to you if you're 25? Like, isn't that an equal protection violation? Now, age is typically not a quote suspect classification, which would be deserving of heightened equal protection scrutiny. But it seems like that's a very irrational law to protect only 60 or 25-year-olds and be like, it's okay to murder everyone else,
Yeah. Well, I think we talked about this before when it was brought up about we talked about licenses or vision tests. There are two different kinds of scrutiny of the law, and under one of them it would pass, under one of them it would fail.
Yeah, so age typically is not a heightened classification. Race is. So if you're like, it's illegal to murder white people, that's not going to be allowed because race is a suspect classification. There's no compelling purpose to say that only white people are protected by the murder laws, and therefore that's going to be struck down very easily. But even for making distinctions on the murder laws, the basic murder laws between 6-year-olds and 60-year-olds, that's going to be tough to even pass rational basis review. What is a legitimate government interest in not protecting 60-year-olds for murder, specifically for murder? That would seem to be an arbitrary law, and that might even fail rational basis review. And now you can make an argument, right? Well, we think murder is not a problem with 60-year-olds because they're such a big burden to our Social Security and shit, right? And they take out they're burden to our healthcare system, so we don't really care if they're murdered. That would be the kind of argument you'd say about abortion. Well, yeah, they're persons, but it's really inconvenient to have the murder laws not apply to these particular kinds of persons. And I think that's just bullshit. If you're going to say that they're persons, I think that states should be required not to, or sorry, I think the stronger argument is, because I'm sure if that were the case, I would argue against it. But I think there's a strong argument that the Equal Protection Clause requires them to extend the murder laws to cover unborn children. But they can't do that here. They can't do that because that's too radical. It's too far. And because this whole opinion is about giving the rights back to the states, right?
Yeah.
And so if you say that we're going to constitutionalize in the other direction, you don't get to have all those juicy quotes about democracy.
Okay.
Sorry, that was a tangent, but you asked it, and it is okay. There are people who think that abortion is not just wrong but unconstitutional.
Yeah. So moving on from that point, God, where the fuck were we?
So we were just talking. What we were talking about was Thomas is saying you guys are wishy-washy. You're changing your rationales. You're being shifty, and so we're at second.
Okay. Second, substantive due process distorts other areas of constitutional law. For example, once this court identifies a fundamental right for one class of individuals, it invokes the Equal Protection Clause to demand exacting scrutiny of statutes to deny the right to others.
That's Eisenstein. That's the case I was talking about, where it was the follow-on case from Griswold.
In which relying on Griswold to invalidate a state statute prohibiting distribution of contraceptives to unmarried persons. Statutory classifications implicating certain non-fundamental rights, meanwhile, receive only cursory review. Similarly, this court deems unconstitutionally vague or overbroad those laws that impinge on its preferred right. I hate the way he fucking writes. While letting slide those laws that implicate supposedly lesser values. And then we have God, I fucking hate the way this guy writes. It makes it so hard to read.
I'll do this paragraph.
Okay.
In fact, I think you're doing a great job. So I love it when you read, but I understand why it's frustrating, and especially because all those citations are there. It can make it for a non-law reader. Like, what am I supposed to read that? Am I supposed to read the parenthetical? Like all that shit. So I'll just do this paragraph. In fact, our vagueness doctrine served as the basis for the first draft of the majority opinion in Roe v. Wade, and it since has been deployed to nullify even mild regulations of the abortion industry. Therefore, regardless of the doctrinal context, the court often demands extra justification for encroachment on preferred rights while relaxing purportedly higher standards of review for less preferred rights, citing Whole Woman's Health versus Hellerstadt, his own dissent. Like, look, he's constantly citing himself. Substantive due process is the core inspiration for many of the court's constitutionally unmoored policy judgments. So step one is you guys can't agree with each other, and this is dangerous because who knows where you're going to go next. And since you can't agree with each other, it shows that this is a dangerous thing. Second, it's a distortionary thing. It messes with our other areas of constitutional doctrine, whether that's extending into the equal protection clause, because the equal protection clause will apply differently if you're dealing with a fundamental right, not just a suspect classification. But if you're having, so think about this, you have the quote unquote fundamental right to vote. It's a little more complicated than that, but just for now, like, you have a fundamental right to vote, right? Now let's say you said something like, people who wear glasses aren't allowed to vote, right? Mm-hmm. Now, wearing glasses is not a suspect class, right? That's not a racial minority. That's like a rational basis review, right? And it might fail rational basis review, to be clear. It might fail rational basis review. But even in the context of, like, with voting, we're, like, more concerned about a fundamental right and classifications that persist on a fundamental right, that we're going to be extra careful with any kind of differential treatment on a fundamental right to vote, for fundamental rights. And so, yeah, you can make sure that prisoners aren't allowed to vote because that's a good justification, but you probably can't be like, I don't know, dumb people aren't allowed to vote, right? Dumb people are not a suspect classification, but you're going to have heightened scrutiny for fundamental rights. And so having a doctrine be tied to fundamental rights and having that doctrine be wrong is distorting our equal protection jurisprudence, he says. It's distorting our vagueness doctrine precedent. And it's requiring us to, like, jump through extra hoops and distort, like, other parts of the law. That's his point here.
God, he's so fucking confusing and offbeat from everybody else. I hate reading Thomas. Okay, go on.
I don't love it either. Third, substantive due process is often wielded to disastrous ends. Okay, so substantive due process, there are some cases where the court finds has found in the past fundamental rights that people disagree with a lot, and so he's pointing to Dred Scott, which detractors of substantive due process say this is this is the first substantive due process case. The argument being, Dred Scott relied on a substantive due process right. It's not as explicit and it's not formalistically in those terms, but that the court implicitly acknowledges that there's a right to own people, a substantive due process right to the property of owning people that can't be taken away.
What is this Gamble citation though?
I don't know. Probably some other. I actually don't know. It's his concurrence. So he's quoting himself in his own concurrence, to be like, this is. That's why people, like, clown on him.
But at least he's concurring. So I mean, like, yeah. I would be interested in what that was like. Because for once he's not. It's not a dissenting.
So you notice that there's like a ___ there. Slip opinion at 16. That case is, like, very recent, so they haven't even put it into, like, the volumes yet, and it's only a slip opinion, like, it's only the opinion itself, and so that's why it's recent. I can look it up real quick while you read the next part if you want. For instance, is where we're at.
For instance, in Dred Scott v. Sanford, the court invoked a species of substantive due process to announce that Congress was powerless to emancipate slaves brought into the federal territories. while Dred Scott was overruled on the battlegrounds of the Civil War and by constitutional amendment after Appomattox. Appomattox. Fuck, I knew I wasn't getting that right. Oh God, I hate that he does this. He puts, okay, whatever. I need to stop.
In the sentence.
That overruling was purchased at the price of immeasurable human suffering.
That overruling was purchased at the price of immeasurable human suffering.
Okay.
So saying, while Dred Scott was overruled, that overruling was purchased at the price of immeasurable human suffering. So he's pointing to Dred Scott and being like, look, that's a substantive due process case. That's pretty shady, bro. You're going to support Dred Scott, and look at what we had to do to undo that precedent. We had to fight a war.
But this second quote is coming from a case in 1995. Like,
what's that? This is so he's citing an opinion himself, right? Where he's recognizing that it wasn't like worth it, right? Like, just because you say it was overruled eventually, that understates how hard it was to overrule it, especially with respect to Dred Scott. Like, it took a civil war to undo that precedent. Now, I think that's a little bit of simplistic outlook on the causes of the war. Like,
sure,
I probably have the Civil War with or without Dred Scott. In fact, I think without Dred Scott, you probably have the war sooner, because Dred Scott was like a pro-slavery position.
Mm-hmm.
But I understand I take his point, which is recognizing the substantive due process right of people to basically think about this. If you have a slave that runs into a free state, if you have a right to that slave, then that other state can't, by virtue of its own laws, take away like a vested property right that you have.
Right. I understand what he's saying.
Okay, got it.
I need to stop talking because all of my criticisms are like meta level. Like, the way he writes is just so fucking annoying to read. It's like he doesn't want to write. He just wants to write through snippets of his own opinions. Like, it's just, it's so annoying. But I shouldn't keep focusing on it because I'll seem like I'm being overly focused on that a certain pejorative that is ableist in nature.
Oh, damn. I will say this. Thomas is a smart guy, you know?
Yeah.
And I don't think you're saying he's dumb.
No.
But there's other words for like this kind of I don't know. It's a little obnoxious to be constantly citing yourself and to doing these like snippet quotes. I understand what you're saying.
Yeah. And he couches quotes and quotes and quotes from different cases, and it's just not something I see a ton in the other justices. It seems to like break from the way that they write, and it makes it really, really hard to read.
I like what one of your chatters says. It's the legal version of a serial killer letter.
So continuing. Now today, the court rightly overrules Roe and Casey, two of this court's most notoriously incorrect substantive due process decisions, after more than 63 million abortions have been performed. The harm caused by this court's forays into substantive due process remains immeasurable.
Okay. That's Thomas being like, abortion is bad, guys.
Yeah, that's he's showing his hand there. And then we have another weird break here that isn't labeled or anything.
Yeah, the opinions will sometimes do that to be like, oh, this is the end, and I'm gonna say a little. I'm about to ruin this guy's day by. This is where you put in your rhetorical flourishes. This is where you want this is the finish line, the photo finish.
Gotcha.
So like justices will often have their juiciest quotes in this after the stars.
and it follows to give people some like practical advice on essay writing. I talk about how your intro is going to be laying out all of your arguments in a way that is more like careful, because you haven't made all your arguments yet, whereas your conclusion is going to be where you bust out the big guns rhetorically, and you're going to speak really, really confidently, because the idea is that in all of your body paragraphs you are making your argument so clear that by the end you've bought buy-in from the audience to be more forceful in your conclusion at the end here, which I'm sure we're about to read. Because the court properly applies our substantive due process precedents to reject the fabrication of a constitutional right to abortion, and because this case does not present the opportunity to reject substantive due process entirely, I join the court's opinion.
The fabrication.
Yeah, it's very
like,
charged.
He's saying that like this is a malicious, like malignant thing. It's a fabrication.
Yes. And yes, to respond to the chat, we have been covering this like pretty in depth. So if you're interested in listening to the oral arguments and having in part some of Pisco's commentary, but not in the form that we have here in my commentary on that, we've been covering this for a while and trying to give it as much attention as possible, and kind of diverting from what Twitch Politics is focusing on to really work in the primary sources here. But in future cases, we should follow the context, the text of the Constitution, which sets forth certain substantive rights that cannot be taken away, and adds, beyond that, a right to due process when life, liberty, or property is to be taken away. Substantive due process conflicts with that textual command and has harmed our country in many ways. Accordingly, we should eliminate it from our jurisprudence at the earliest opportunity.
So Thomas is saying, I'm ready to get rid of all these cases. I'm ready to get rid of Bergefell. I'm ready to get rid of Lawrence. I'm ready to get rid of Griswold. Send me the right case and I'll do it. He's saying the only reason I'm not doing it right now is because we don't have the opportunity. But if I had the opportunity, I would do it. That's what this is saying. And to take a minute, let's I want to hear. I'm going to give you an argument for why you should be worried and why you shouldn't be worried.
Okay.
I'll start with like why you should be worried. You should be worried because the logic of the court's majority opinion, its emphasis on history, while it doesn't signal that it's ready to step away totally from substantive due process, I think that
love these law streams.
Kavanaugh,
doing more. Thanks,
who
Pisco,
probably would not want to move forward on that. Well, it doesn't signal like a retreat from substantive due process. At the very least, it signals a supremacy of history and tradition, a very strong focus on history and tradition at a somewhat narrow level at the time that the 14th Amendment was passed. So that means 1860s. And so logically, even if abortion is different than these other rights, and it is different, the history analysis you get messed up on gay marriage, right? Now you can think of that as an equal protection case. Maybe you can think about the sodomy as an equal protection case, unless the state said something like sodomy is illegal no matter if you're gay or straight, right? They don't have to say that gay sodomy is illegal. They can say all sodomy is illegal, and then like only apply it to gay people, and that wouldn't be an equal protection problem there, I don't think, because I don't think that like different sexual acts. Does anal sex get more protection or just as much protection as vaginal sex? No, people get protection, right?
Right.
So all those cases in terms of history analysis, certainly contraception, like what's the fucking history and tradition of an affirmative right to contraception in the 1860s? It doesn't exist, it doesn't exist.
Yeah.
So by the logic of the opinions, I think that those decisions, at least on the fundamental rights portion of the analysis, go away. Go ahead.
Yeah, I the only thing I have to add is like, and I've only read bits and pieces from the other opinions, but what I don't see people worried about the most is Thomas. I feel like Thomas is the most worrisome of the opinions that I've read so far, but I see people focus on people like Kavanaugh that I feel like from what bits I've read is far less worrisome than Thomas's opinions on stuff.
Oh yeah. Thomas is like a centrist compared to. He is the center of the court.
He's like chaotic neutral.
Yeah. I would say Clarence Thomas is lawful evil.
Okay.
In some ways he can be chaotic too. But I'm glad you brought up the Clarence Thomas point, because that's the reason why, and the Kavanaugh point, that's the reason why I think you shouldn't despair. Because even though I think the logic of the court's opinion says those other rights have to go too, really and practically, Clarence Thomas's opinion isn't signed by anyone else, right?
Right.
It's just Thomas.
It's just him in his corner with his own weird interpretations of things.
Now, I think you absolutely have Alito and Barrett and Gorsuch votes to overturn Obergefell and all these other cases, and they'll say the same exact things. They'll say, give it back to the people to decide on gay marriage, all that stuff. Everything you say about abortion, they'll say about gay marriage. But I don't think you have Kavanaugh. I don't think you have Kavanaugh. And I think the chief cares more about stare decisis than everyone else in the conservative majority. I mean, the chief was willing to uphold hold women's health in a case called June Medical. It's an abortion case. A couple years after he dissented in the case that he was upholding. That's how strong it is for the chief, right? The chief in an abortion case in 2016 was in the dissent, wrote the dissent. And nonetheless, in 2020, the same kind of abortion law was up for analysis, and the chief concurs and maintains that law is unlawful, unconstitutional, even though he was in the dissent in 2016. And that's a case with no history, right? That's a case with, it's a 4-year-old case. It doesn't have Roe v. Wade's long tradition of, from the 1970s. And so the chief, I think, is a vote to maintain stuff. And so
when we're talking about chief, are we talking about Roberts?
Chief, yeah, the Roberts.
Okay.
Chief Roberts.
Just to clarify.
Yeah, right. So even though the logic of the opinion, I think, would overturn those rights, and I think that those rights are in danger of being curtailed in some ways, for them to be totally obliterated, I think you need Kavanaugh. And I think Kavanaugh has kind of signaled more of a reluctance there. So but you're hoping on Kavanaugh. Just because the majority opinion says this doesn't affect anything doesn't mean anything, folks. It's not before them. Obergefell and those cases are not before them, and so them saying that this case doesn't affect those rights, they're just saying something that's just true, which is we're not meant to decide cases. Guess what else isn't before them? Whether or not macaroni and cheese is better than angel hair pasta, but it's just not before them. If it is before them, don't rely on them. You have to rely on Kavanaugh. That's it. And it's so ironic, I think, given everything that happened in the Kavanaugh hearings, that liberal and left-wing people are dependent on him now.
Yes, and that's part of why I like reading these primary sources, is because I think you'll get opinions and you'll develop a kind of view on things that won't be in line with what the media is feeding you. And I think it'll be more in line with what you actually should be worried about and who the actual players are and how they're a part of things in a way that wouldn't be clear to you if you didn't read these. I think reading these, you're way more afraid of Thomas in a way that I don't see portrayed on the media, or you realize your reliance on Kavanaugh in a way that I don't think you would realize if you didn't read through these.
True. Very, very, very true.
Yeah.
I'm much more scared of Alito and Thomas than I am of Kavanaugh. And also yesterday I read late night an opinion by Justice Gorsuch, a dissenting opinion, where Gorsuch is super based about Indian rights. I'm saying Indian because that's the proper term in the law, and also with respect to the tribes at issue, I believe they prefer to be called Indians.
Yes.
Just to be clear. And so in that opinion, Gorsuch is very based in favor of these tribal lands being their own sovereigns. And so you lose that nuance if you're not really a critical thinker if you're just the conservative justices are the same. They're different. They're very problematic in their own ways. and it's very alarming what the court has been doing. But to not be aware of the differences and the potential nuances, you're in some sense being a sheep, and you're not preparing yourself for what's likely to happen in the future and what kind of arguments you might bring to bear against one justice or another.
Mm-hmm. And yeah, so that's why I think more streamers should probably try to focus on the briefs and on the opinions. But
Wait.
What's that?
We can skip around in Kavanaugh's opinion real quick just to get the most important parts if you want. Or up to you.
Sure. I mean, if we're limited on time, or we could. Oh, go ahead.
Go ahead. Sorry, sometimes it breaks up and I interrupt you. I'm not trying to interrupt you.
No, you're good. I don't think his is super long, if I remember right.
All right. Let's get it then.
Okay. So we'll try to Rochambeau through it. Justice Kavanaugh in the concurring. I write separately to explain my additional views about why Roe was wrongly decided and why Roe should be overruled at this time and the future implications of today's decision.
Boom, 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 boom. That's the most important part. The future implications. He's writing separately to say what this opinion's implications are. It's kind of an advisory opinion, which isn't what this court's supposed to be doing, right? The court's only supposed to be deciding cases before it, but Kavanaugh is writing separately to be like giving roadmaps to people on how he's going to vote in the future.
Yeah.
Which isn't like technically what you're supposed to be doing. Now, to be clear, Clarence Thomas is also doing that, but so is Kavanaugh.
Yeah. Abortion is a profoundly difficult and contentious issue because it presents an irreconcilable difference between the interests of a pregnant woman who seeks an abortion and the interest in protecting fetal life. The interests on both sides of the abortion issue are extraordinarily weighty. On the one side, many pro-choice advocates forcefully argue that the ability to obtain an abortion is critically important for women's personal and professional lives and for women's health. They contend that the widespread availability of abortion has been essential for women to advance in society and to achieve greater equality over the last 50 years, and they maintain that women must have the freedom to choose for themselves whether to have an abortion. On the other side, many pro-life advocates forcefully argue that a fetus is a human life. They contend that all human lives should be protected as a matter of human dignity and fundamental morality, and they stress that a significant percentage of Americans with pro-life views are women. When it comes to abortion, one interest must prevail over the other at any given point in a pregnancy. Many Americans of good faith would prioritize the interests of the pregnant woman. Many other Americans of good faith instead would prioritize the interest in protecting fetal life, at least unless, for example, an abortion is necessary to save the life of the mother. Of course, many Americans are conflicted or have nuanced views that may vary depending on the particular time in pregnancy or the particular circumstances of a pregnancy. The issue before this court, however, is not the policy or morality of abortion. The issue before this court is what the Constitution says about abortion. The Constitution does not take sides on the issue of abortion. The text of the Constitution does not refer to or encompass abortion. To be sure, this court has held that the Constitution protects unenumerated rights that are deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. There's that and. But go ahead.
Go ahead. Sorry, my bad.
Do you want me to continue or just a note?
After the paragraph. Yeah, after the paragraph, I'll have something to say. Sorry.
But a right to abortion is not deeply rooted in American history and tradition, as the court today thoroughly explains.
So there is Kavanaugh saying, this court has held that the Constitution protects unenumerated rights that are deeply rooted in the nation's history and tradition and implicit in the concept of ordered liberty. Now, keep in mind, all Kavanaugh is saying is that the court has held that. Mm-hmm. Now, the court has held that. But by saying that, he seems to be, I think a plausible reading is that Kavanaugh agrees that it's okay to do this. Mm-hmm. So I think that a practical reading of what Kavanaugh is saying here is Kavanaugh's okay with implied fundamental rights. At the very least.
Right.
And so he's okay with something that like book. I think you have a right to be a little bit like, where is this coming from? What's weird about this? But even Kavanaugh, right, is saying, I agree that, or at least it seems, right, that the court has held that implied fundamental rights exist, but abortion is just not one of them, you know?
Yeah, because of that second sentence where he's
right.
like, but this one in particular doesn't fit that bill.
Right. And so I think that the whole doctrine of implied fundamental rights, now he doesn't say that it's in the due process clause. He doesn't say substantive due process, but he does. And so you can still have implied fundamental rights under the privileges or immunities clause with all the kind of caveats we talked about before. But he doesn't, he seems to be more positive of the existence of implied fundamental rights than Clarence Thomas. Clarence Thomas, who says that there might be implied fundamental rights in the privileges or immunities clause, but stops short of saying that there are. Now, Kavanaugh doesn't say that there are, but his language, just from how he says it, that there's your rhetoric for you, seems to suggest that he's going to be way more positive about finding that than Clarence Thomas would.
Right. And I like that in the entire way that he's writing this, he's couching it in the modern kind of political and philosophical disagreements between people, and then putting the court outside of that, which he's going to do in the next paragraph as well. On the question of abortion, the Constitution is therefore neither pro-life nor pro-choice. The Constitution is neutral and leaves the issue for the people and their elected representatives to resolve through the democratic process in the states or Congress, like the numerous other difficult questions of American social and economic policy that the Constitution does not address. Because the Constitution is neutral on the issue of abortion, this court also must be scrupulously neutral. The 9 unelected members of this court do not possess the constitutional authority to override the democratic process and to decree either a pro-life or a pro-choice abortion policy for all 330 million people in the United States.
Odds. Very pro-democratic, right?
Yes.
Now, one thing that's been popping around is that Congress should pass a federal law codifying Roe v. Wade, right? However, the federal government can only do what its enumerated powers say it can do. That's explicit. Everyone knows that. There's no debate on that. And there's precedent. Most of the time, the Congress is doing a lot of these sweeping changes on the basis of the Interstate Commerce Clause of Article 1 of the Constitution. This court, if it came to be that there was a federal abortion law passed by Congress, eventually this court would be faced with the question about whether that law was constitutional as an overseeing congressional authority question, as a powers question, whether or not Congress has the power and authority to codify Roe v. Wade. And just remember this line about democratic process and whether or not the court has a right to make a decision over and above the political branches. When that decision, if they pass that law and when that law comes to the Supreme Court, remember all these quotes about democracy then. Because I have a feeling this court would strike down that law.
I suppose we'll see. Instead of adhering to the Constitution's neutrality, the court in Roe took sides on the issue and unilaterally decreed that abortion was legal throughout the United States up to the point of viability, or about 24 weeks of pregnancy. The court's decision today properly returns the court to a position of neutrality and restores the people's authority to address the issue of abortion through the processes of democratic self-government established by the Constitution. Some amicus briefs argue, and that's, again, friend of the court briefs, that's coming from part outside of the two involved in the case. Some amicus briefs argue that the court today should not only overrule Roe and return to a position of judicial neutrality on abortion, but should go further and hold that the Constitution outlaws abortion throughout the United States. No justice of this court has ever advanced that position. I respect those who advocate for that position, just as I respect those who argue that this court should hold that the Constitution legalizes pre-viability abortion throughout the United States. But both positions are wrong as a constitutional matter, in my view. The Constitution neither outlaws abortion nor legalizes abortion.
Pause. Kavanaugh is suggesting, and I think, he's saying that the person, remember we spent like 5 minutes talking about whether personhood starts at conception and the equal protection. That's the argument, is that abortion is unconstitutional as a matter of law. And what Kavanaugh is saying is that he thinks that that's wrong. And so he seems to suggest that it's not the correct position to say that the Constitution outlaws all abortion. And so that argument seems dead in the water.
And sorry if we dropped out for a second there. I'm sure that YouTube stayed up the whole time.
Not bad.
So
was that me or was that your stream?
No, it was just a stream.
Okay.
And again, I will say, if you make fun of Pisco and it has absolutely nothing to do with what we're talking about, from here on out, I'm calling shenanigans on that. And I'm just going to block you entirely if you're on YouTube chat. And if you're on Twitch chat, I'll time you out for 30 minutes because it is getting annoying. I can understand if Pisco says something that you disagree with, then you can, properly explain what it is that you disagree with and why, and that's totally fine. But if you're just making fun of him and calling him names or talking about positions that he holds that have absolutely nothing to do with what we're talking about, I'm just going to time you out for a long time. Because it has nothing to do with what we're talking about.
What were they saying?
It's just like name calling and stuff, like calling you piss cup or insulting your understanding of the law. Like it's just silly.
Listen, guys, I'm not even taking necessarily like a position here. I'm giving my interpretation of what they're saying, and what I'm saying is actually that Kavanaugh is not being a radical here. That he's like, I don't know what there is to disagree about.
It has very little to do with what you're saying, which is my whole point.
But yeah, I appreciate that, Boogie.
Yeah. To be clear, then, the court's decision today does not outlaw abortion throughout the United States. On the contrary, the court's decision properly leaves the question of abortion for the people and their elected representatives in the democratic process. Through that democratic process, the people and their representatives may decide to allow or limit abortion. As Justice Scalia stated, the states may, if they wish, permit abortion on demand, but the Constitution does not require them to do so. Today's decision, therefore, does not prevent the numerous states that readily allow abortion from continuing to readily allow abortion. That includes, if they choose, the amici states supporting the plaintiff in this court: New York, California, Illinois, Maine, Massachusetts, Rhode Island, Vermont, Connecticut, New Jersey, Pennsylvania, Delaware, Maryland, Michigan, Wisconsin, Minnesota, New Mexico, Colorado, Nevada, Oregon, Washington, and Hawaii. By contrast, other states may maintain laws that more strictly limit abortion. After today's decision, all of the states may evaluate the competing interests and decide how to address this consequential issue. In arguing for a constitutional right to abortion...
Wait. Footnote 2.
Okay, footnote 2. In his dissent in Roe, Justice Rehnquist indicated that an exception to a state's restriction on abortion would be constitutionally required when an abortion is necessary to save the life of the mother. Abortion statutes traditionally and currently provide for an exception when an abortion is necessary to protect the life of the mother. Some statutes also provide other exceptions.
So look at what he's saying there. He's also indicating that by saying that, he's not doing that for no reason, that Kavanaugh probably would say that if you have an abortion law that doesn't have an exception for the life of the mother, that law would probably be unconstitutional, at least as Kavanaugh sees it, right? He's citing the dissent in Roe and being like, even Justice Rehnquist, who was the dissenter in Roe when it was a 7-2 decision, said that there would be a constitutionally required exception for the life of the mother to have an abortion. In other words, like, if you don't let mothers have abortions to save their own lives, that would be unconstitutional. And so he seems to be suggesting that, like, if you don't have that exception, we might have to strike down that law. or at least imply a constitutional exception there to your anti-abortion law.
That's an interesting interpretation of the footnote there, because I saw that as only pertaining to consequential issue insofar as like the consequences of whether you lean one way or the other could mean that a mother's life could be put in jeopardy. And there's a lot to determine there, because this could have consequences to the mother as well as the fetus, depending on which side of the aisle you land on. And that's something that you should take into consideration when writing your laws, particularly if you're going to limit the access to abortion.
I don't read that footnote that way. I think what the footnote is saying here is like, you can weigh all these different things, footnote 2, but just keep in mind, folks, that this thing seems to be, some smart people think that this thing is out of consideration for the states, and that thing is not having an exception. So I think that what he's saying is like, you can do competing interest analysis and how you can decide how you want to address this question, but footnote 2, just to be clear, there could be some constitutional issues here with not allowing an exception. That's how I read it.
Gotcha. And if that is his purpose in the footnote, then it is a very like underhanded or very passive way to like indicate. Yeah, absolutely
very passive, absolutely not explicit. But I think, and reasonable minds can differ on why he had it there. But I think he's saying that we're not just going to necessarily let you do anything. Just watch yourself, states. There's going to be some, if you do some crazy stuff, we're gonna be here. And like, that's why he says that most laws do offer those exceptions, or that exception, right?
Gotcha.
Him calling and saying like, we don't have to worry about it today, is being like, yeah, all these laws traditionally provide for an exception for the life of the mother.
Yeah. And if you lean on that interpretation rather than this having to do with competing interests and consequential issue, then it may, again, be an indication that Kavanaugh may be your guy in defending these rights, or at least having like a level-headed discussion about the interests involved in these different rights. And so of all the conservatives that we'll probably read today, I think that Kavanaugh is going to be one of those votes that you should really keep an eye on.
Yeah, he's a swing vote. He absolutely is a swing vote. Him and the Chief Justice. But he's absolutely the center of the court.
Yeah,
he's very conservative, guys. But these other guys are much more conservative.
Yeah. In arguing for a constitutional right to abortion that would override the people's choices in the democratic process, the plaintiff and Jackson Women's Health Organization and its amici, amici or amici when it's plural? Amici, okay. And its amici emphasize what the Constitution does not freeze the American people's rights as of 1791 or 1868. What exactly is he saying here?
Oh, so he's saying that there are some amici who are like, hang on, because one of the criticisms is what the court is doing is freezing in time all the situations in the 1800s and saying that our rights are just whatever the rights were back in the day, And so that's one of the criticisms is like, you didn't think about women back then. You're trying to hold us to like this old standard. We're way, 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 way advanced beyond that. And like, you're trying to freeze in time the conditions as they existed when they passed the Bill of Rights 1791, or when they passed the 14th Amendment 1868, or when they ratified it, right? What he's saying is like, no, it's not frozen in time, but, and you can read the next lines. I agree, I fully agree. To begin.
Gotcha. Well, when I'm reading this, and the reason why I'm confused is because that seems to go against what he's saying here. The plaintiff, Jackson Women's Health Organization, which, to be clear, would be on the side of anti or pro-abortion?
Pro-abortion.
Gotcha. And its amici emphasize that the Constitution does not freeze the American people's rights as of 1791 or 1868.
Yeah, they're saying like, unlike what the majority opinion, or unlike our Mississippi, unlike these states, unlike these conservatives, the Constitution isn't just there to freeze rights at the time of their enactment.
Gotcha.
And Kavanaugh is saying, I agree with that, but he's got his own.
Yeah, he's got his own twist on that. I fully agree. To begin,
Hello?
Oh, yeah, you just cut out for a second. I fully agree To begin, I agree the constitutional rights apply to situations that were unforeseen in 1791 or 1868, such as applying the First Amendment to the internet or the Fourth Amendment to cars. Moreover, the Constitution authorizes the creation of new rights, state and federal, statutory and constitutional. So disagreeing with Thomas there. But when it comes to creating new rights, the Constitution directs the people to the various processes of democratic self-government contemplated by the Constitution: state legislation, state constitutional amendments, federal legislation, and federal constitutional amendments.
To be clear, I don't think he's disagreeing with Thomas right there necessarily. Thomas, he's saying that the Constitution authorizes the creation of new rights. But the Constitution does not give those new rights. It authorizes their creation, but it doesn't put them into action. He's saying that you have to go to political branches for that. And that's, I think Thomas would agree with that. But notice something else. He says it doesn't freeze in time the rights that existed then, because you can apply constitutional principles to new situations, but you can't change what they apply to if those situations existed at the time, right? Mm-hmm. And you can't just whole cloth create new stuff. You can apply constitutional rights that we agree exist to new situations, but you can't change what those things are in terms of like what they are at base, and you can't just make them out of whole cloth. To do that, you need democracy.
Yes. So that would go back to that history and tradition we saw in the majority opinion, where you need to be looking at where are the laws at currently and use that to guide your hand in determining what's going on here constitutionally. That if the laws are saying one thing, you can't just like go against it entirely and then fill in the blank with your own opinion. Instead, you need to kind of be moderated by where state legislation, state constitutional amendments, and whatever are at. Right?
Yeah, I think that he's saying essentially that it makes sense for the Constitution to apply to new situations. So think about like what he mentioned with the First Amendment and the Fourth Amendment. Like when they enacted the Fourth Amendment or the Second Amendment, were they just saying, well, let's do the Second Amendment as the easiest one, that the Second Amendment only applies to guns that existed at that time? And the answer is like, no. It doesn't apply just to the things that existed at the time. There are new situations. There are tasers. There's nukes. And so potentially the Second Amendment can cover more stuff. But you can't just go back in time and say the Second Amendment applies to, let's say that you say that the Second Amendment applies to swords, and for whatever reason that it didn't include swords back at that time. Swords existed at the time of the founding. And so you can't change it and be like, okay, now swords are included where before they weren't included. And likewise, you can't just be like, okay, we can just make up a right. You have to go back to, like, as you said, what were the laws at the time? What was the common law? What is our history and tradition? And so that's what he's focusing on.
And if a right doesn't exist there, then your efforts should be directed at the democratic process to create and define those rights so that the court could then use those in reference to their decisions, right?
Yeah.
Gotcha.
Boom. You got it.
The Constitution does not grant the 9 unelected members of this court the unilateral authority to rewrite the Constitution to create new rights and liberties based on our own moral and policy views. As Justice Rehnquist stated, this court has not, quote, been granted a roving commission, either by the Founding Fathers or by the framers of the 14th Amendment, to strike down laws that are based upon notions of policy or morality suddenly found unacceptable by a majority of this court.
Real quick, just on your point about how Justice Thomas writes, look at how much cleaner that quote is.
Yeah.
You know, he just, and he did it before too. Kavanaugh's like quotes. He'll end his sentences with quotes, and he won't just like embed the quotes. He'll put the citation like at the end, right? All the citations there are like at the end there of the sentence. Mm-hmm. And so, like, definitely, like, I think a lot cleaner to read. And you have more confidence that the quote he's citing is like the correct quote, you know, not just citing himself, citing Justice Rehnquist and all that stuff. So he's a lot less obnoxious to read.
Yeah, and to give context to some people on why I might have some difficulty, another thing is that parentheticals, or the citation you're actually giving for where quotes are coming from, generally in essay writing will come at the end of a sentence. So even if you're quoting from multiple sources at one time, those multiple sources and their citation will come at the end of the sentence. Whereas it seems like the way that these court documents are written, the citation and its information about where the quote is coming from always needs to follow the quote. So if you're quoting two different sources in the same sentence, you're going to have your citation immediately after each quote, which means that you're going to have a bunch of citations with information on where a quote is coming from in the middle of a sentence if it's different from the quote that you're going to use at the end of your sentence. And that makes it really hard to read.
And it would be one thing if you did it like once or twice, but like he's doing it a lot, you know?
Over
and so
and over.
Booksmart is like frustration there for sure.
Yeah. This court, therefore, does not possess the authority either to declare a constitutional right to abortion or to declare a constitutional prohibition on abortion. In sum, the Constitution is neutral on the issue of abortion and allows the people and their elected representatives to address the issue through the democratic process. In my respectful view, the court in Roe therefore erred by taking sides on the issue of abortion. Section 2. The more difficult question in this case is stare decisis, that is, whether to overrule the Roe decision. The principle of stare decisis requires respect for the court's precedents and for the accumulated wisdom of the judges who have previously addressed the same issue. Stare decisis is rooted in Article 3 of the Constitution and is fundamental to the American judicial system and to the stability of American law.
Okay, so all of you like losers in the... Now, Thomas doesn't care. Did you see anything in Thomas's concurrence about stare decisis?
No, besides the references to Washington v. whatever.
Right. Yeah. So he doesn't really care about stare decisis, but most people on this court, most people on this court will say that they care about stare decisis and will describe it as fundamental. So all you people who are like, stare decisis, it doesn't matter, you just go, you maintain wrong decisions. Even the conservative justices in this court overruling Roe and Casey say that stare decisis is fundamental. You know what fundamental means? Fundamental means necessary. It's vital. It's critical. So I'm not a weirdo for saying that stare decisis matters. And stare decisis absolutely, it only matters with respect to wrong opinions, because of course no one's going to overturn correct opinions. So you don't need stare decisis for correct opinions. And so that's essentially, you know, for someone to say stare decisis is fundamental, what you're saying is it is fundamental for our judicial system to maintain some wrongly decided cases. Even the conservative justices, except for Thomas, say at least that they agree with that principle. And so you guys should really, I think, take it easy on Destiny when he says like similar stuff. He's not saying you don't overturn Plessy. He's not saying you don't have Brown v. Board. There are factors that you apply. You can overrule some cases, but that there's a strong bias in favor of precedent. That's all stare decisis is about, and you're going to see Kavanaugh talk about it in the next paragraph.
Yeah, and furthermore, on the point of stare decisis, every time I see it brought up, it's important to remember, and this is how I visualize it in my mind, it is like a coin. It has two faces to it. On the one hand, it's talking about the need to uphold precedent and whatever, and it's fine to focus on that. But it seems like the discussion around it is also about the flip side of that coin. In what cases do you overrule precedent? And it can't just be that something is erroneously wrong. There's more to it than that, because like erroneously wrong is simply step one in considering whether or not to overturn precedent. Then you need further guidance on what goes beyond that to enable you to go against prior rulings, right?
Now, yes, generally yes. Although this is the hard hypo here, Booksmarts.
Okay,
and this is something that the majority gets the dissent on. The dissent has an answer to it. I don't know that it's the most satisfying answer.
Okay,
but I'm about to give it to you. The hypo. Let's say that Plessy versus Ferguson comes down on Monday, and then 1 year later, you have a case where you can overturn Plessy versus Ferguson. Typically, a lot of the stare decisis factors aren't in your favor to overturn it. There hasn't been development in facts, right? It's only been a year. There hasn't been a development in the law. No significant reliance has been built up on that decision. It's only a year old. Would you still overturn it, even just because it's egregiously wrong? The dissent has an answer to that, but just keep that in mind. Is there ever a case where the case is just so wrongly decided that you're allowed to overturn it just for being so wrongly decided? I think generally, I think the answer is like no. There has to. It's a hard question. Maybe the answer is it has to be like the most egregious mistake for me to say that. But typically, I would say it needs to be more than just wrong. There needs to be, as you said, other things. That's just step one, typically.
Yeah.
But just remember, there are hypos about what if it's like, the court says America doesn't exist anymore, or something like so absurd. Are you going to maintain that precedent even though you're not applying the factors? Just keep that in mind.
Yeah. And to address something that I keep seeing repeated time and time again in the chat, and it's starting to piss me off. I don't think it's fair to say that Kavanaugh here, or any of the conservative justices, because it's not the first time I'm reading this, are gaslighting you or are pretending to be more indifferent to the decision than they are. I don't feel like it's fair to apply that to Kavanaugh or many of the justices here. And if you do, then provide some specifics about where you see the difference in opinion is versus what they're actually purporting here. Like in here, he says he can see both sides of this argument, but ultimately it's not their place to be deciding which side of the argument is correct here. Like, I don't know. He seems to be walking the line really, really well. And to say that he's gaslighting you, or that he's full of shit, or that he's hiding his power level or whatever, I feel like is just wrong-headed. And I don't think without further elaboration that makes any sense to me.
Yeah, I think that's the key part. Like, you need evidence for that. You need to be able to support it. I happen to think the majority, if anyone's gaslighting, I think Alito is. But you should be able to cite why you think he's gaslighting. Like for Alito, I would be like, he's gaslighting because he's using quotes from Roe in a different way than the Roe court used them, and is trying to use that for, like, he's twisting them. But you need to be able to explain why. And Kavanaugh here, I think, is less gaslighty than Alito. And I don't think Clarence Thomas is gaslighty at all. He's just a burning inferno, right? Yeah. He's very clearly like being honest about almost to a fault and being like, no, bro, I'll definitely overturn these cases. And so I don't think you could call that gaslight. I think he's just being like, I don't give a shit about these cases and I'll overturn them. So if anyone I think is being gaslighting, maybe you can accuse the majority of it, but I don't know if Kavanaugh and Thomas are good, at least on this particular issue, from what I can think of right now, are good people to accuse of that at the moment.
No. And you need to really, and I'm going to keep emphasizing this, you need to sort out your personal feelings and opinions on Kavanaugh, which are likely coming from the whole media storm around him being put into power as a judge. You really need to resolve those, because Kavanaugh is going to be one of your lifelines on many cases to come. And I think you need to, sooner rather than later, sort out your feelings on him, because he's going to be essential in getting decisions going one way or the other, likely in favor of some of the decisions going the way you would like them to go. So I really think that you have to sort out your feelings on this guy, and you really need to consider beyond just what you saw in his in the questioning that he went through. In his canonical Bernay opinion in 1932, Justice Brandeis stated that in cases involving the federal constitution where correction through legislative action is practically impossible, this court has often overruled its earlier decisions. That description of the court's... Sorry, I got interrupted by a alert.
No worries.
That description of the court's practice remains accurate today. Every current member of this court has voted to overrule precedent. And over the last 100 years, beginning with Chief Justice Taft's appointment in 1921, Every one of the 40 appointed to this court has voted to overrule precedent. Many of those justices have voted to overrule a substantial number of very significant and long-standing precedents, like in Obergefell, or Brown v. Board of Education, or West Coast Hotel versus Parrish, etc. But that history alone does not answer the critical question: when precisely should the court overrule an erroneous constitutional precedent? The history of stare decisis in this court establishes that a constitutional precedent may be overruled only when 1. The prior decision is not just wrong, but is egregiously wrong. 2. The prior decision has caused significant negative jurisprudential or real-world consequences. And 3. Overruling the prior decision would not unduly upset legitimate reliance interests. Applying those factors, I agree with the court today that Roe should be overruled. The court in Roe erroneously assigned itself the authority to decide a critically important moral and policy issue that the Constitution does not grant this court the authority to decide. As Justice Byron White succinctly explained, Roe was, quote, an improvident and extravagant exercise of the power of judicial review, because nothing in the language or history of the Constitution supports a constitutional right to abortion. Of course, the fact that a precedent is wrong, even egregiously wrong, does not alone mean that the precedent should be overruled. But as the court today explains, Roe has caused significant negative jurisprudential and real-world consequences. By taking sides on a difficult and contentious issue on which the Constitution is neutral, Roe overreached and exceeded this court's constitutional authority, gravely distorted the nation's understanding of this court's proper constitutional role, and caused significant harm to what Roe itself recognized as the state's important and legitimate interest in protecting fetal life. All of that explains why tens of millions of Americans and the 26 states that explicitly asked the court to overrule Roe do not accept Roe even 49 years later. Under the court's long-standing stare decisis principles, Roe should be overruled. But the stare decisis analysis here is somewhat more complicated because of Casey. In 1992, 19 years after Roe, Casey acknowledged the continuing dispute over Roe. The court sought to find common ground that would resolve the abortion debate and end the national controversy. After careful and thoughtful consideration, the Casey plurality reaffirmed a right to abortion through viability, or about 24 weeks, while also allowing somewhat more regulation of abortion than Roe had allowed. I have deep and unyielding respect for the justices who wrote the Casey plurality opinion, and I respect the Casey plurality's good faith effort to locate some middle ground or compromise that could resolve this controversy for America. But as has become increasingly evident over time, Casey's well-intentioned effort did not resolve the abortion debate. The national division has not ended. In recent years, a significant number of the states have enacted abortion restrictions that directly conflict with Roe. Those laws cannot be dismissed as political stunts or as outlier laws. Those numerous state laws collectively represent the sincere and deeply held views of tens of millions of Americans who continue to fervently believe that allowing abortions up to 24 weeks is far too radical and far too extreme, and does not sufficiently account for what Roe itself recognized as the state's important and legitimate interest in protecting fetal life. In this case, moreover, a majority of the states, 26 in all, asked the court to overrule Roe and return the abortion issue to the states. In short, Casey's stare decisis analysis rested in part on a predictive judgment about the future development of state laws and of the people's views on the abortion issue. But that predictive judgment has not borne out. As the court today explains, the experience over the last 30 years conflicts with Casey's predictive judgment and therefore undermines Casey's precedential force. In any event, although Casey is relevant to the stare decisis analysis, the question of whether to overrule Roe cannot be dictated by Casey alone. To illustrate that stare decisis point, consider another example. Suppose that in 1924, this court had expressly reaffirmed Plessy v. Ferguson and upheld the state's authority to segregate people on the basis of race. Would the court in Brown, some 30 years later, in 1954, have reaffirmed Plessy and upheld racially segregated schools simply because that intervening 1924 precedent? Surely the answer is no. In sum, I agree with the court's application today of the principles of stare decisis and its conclusion that Roe should be overruled. Section 3. After today's decision, the 9 members of this court will no longer decide the basic legality of pre-viability abortion for all 330 million Americans. That issue will be resolved by the people and their representatives in the democratic process in the states or Congress. But the parties' arguments have raised other related questions. Go ahead.
Wait, just real quick on that paragraph. That issue will be resolved by the people and their representatives in the democratic process in the states or Congress. So I don't think this decides the question, but Kavanaugh seems to be suggesting that the issue might be resolved in Congress, and therefore it might be constitutional for Congress to codify Roe or codify at least some abortion rights.
Mm-hmm.
And now he's taking the opportunity. Let me just answer some questions that weren't at issue in the case, but I'm just going to talk about them anyway.
But the parties' arguments have raised other related questions, and I address some of them here. First is the question of how this decision will affect other precedents involving similar issues, such as contraception and marriage. In particular, the decisions in Griswold v. Connecticut, Einstadt v. Baird, Loving v. Virginia, and Obergefell v. Hodges. I emphasize what the court today states. Overruling Roe does not mean the overruling of those precedents and does not threaten or cast doubt on those precedents. Second, as I see it, some of the other abortion-related legal questions raised by today's decision are not especially difficult as a constitutional matter. For example, may a state bar a resident of that state from traveling to another state to obtain an abortion? In my view, the answer is no, based on the constitutional right to interstate travel. May a state retroactively impose liability or punishment for an abortion that occurred before today's decision takes effect? In my view, the answer is no, based on the Due Process Clause or the ex post facto clause. Really, really important, those 2 points here, I feel like, from Kavanaugh, because he's explicitly stating his position on those.
So that's when I reference you in DMs, like, yeah, the majority opinion holds, but for questions that aren't answered, people will look to the Kavanaugh concurrence because that's like probably going to be a deciding vote on that question, and so they'll probably cite this opinion. Real quick on the first part, it does not threaten or cast those doubt on those presidents. I just think that that's BS. That's BS from a formal perspective. They absolutely do cast doubt and threaten. If anything, because states are going to challenge those precedents. And so to say that that the decision does not do that, it's just not true as a factual matter. It's not true as like a legal. This is my polemicist hat. It's not true as a formal legal matter based on the logic of the opinion. And it's only true because Kavanaugh says it's true and because we're meant to trust him. That's my opinion. Put that into brackets. That's Pisco's opinion. But I don't think that factually it's true. I don't think that legally it should be true. I think it's only true because Kavanaugh says it's true and because Kavanaugh's on the Supreme Court.
Sure. And he's very specific in saying overruling Roe, because if we look at the concurring opinion from Thomas, you very much so should be afraid about Thomas's ruling on those rights, because he explicitly asks you to be afraid. He's like, be very afraid, because I'm looking to say the same exact thing about these other rights. Second, as I see it, some of the other abortion-related legal questions raise. I already read that. My bad. Right? Yeah. Other abortion. The second.
Yeah. Oh, no. Yeah, you already read that. Other abortion.
Yeah. Other abortion-related legal questions may emerge in the future, but this court will no longer decide the fundamental question of whether abortion must be allowed throughout the United States through 6 weeks, or 12 weeks, or 15 weeks, or 24 weeks, or some other line. the court will no longer decide how to evaluate the interests of the pregnant woman and the interests in protecting fetal life throughout pregnancy. Instead, those difficult moral and policy questions will be decided as the Constitution dictates by the people and their elected representatives through the constitutional process of democratic self-government. The Roe court took sides on a consequential moral and policy issue that this court had no constitutional authority to decide. By taking sides, the Roe court distorted the nation's understanding of this court's proper role in the American constitutional system and thereby damaged the court as an institution. As Justice Scalia explained, Roe, quote, destroyed the compromises of the past, rendered compromise impossible for the future, and required the entire issue to be resolved uniformly at the national level. The court's decision today properly returns the court to a position of judicial neutrality on the issue of abortion and properly restores the people's authority to resolve the issue of abortion through the processes of democratic self-government established by the Constitution. To be sure, many Americans will disagree with the court's decision today. That would be true no matter how the court decided this case. Both sides on the abortion issue believe sincerely and passionately in the rightness of their cause. Especially in those difficult and fraught circumstances, the court must scrupulously adhere to the Constitution's neutral position on the issue of abortion. Since 1973, more than 20 justices of this court have now grappled with the divisive issue of abortion. I greatly respect all of the justices, past and present, who have done so. Amidst extraordinary controversy and challenges, all of them have addressed the abortion issue in good faith after careful deliberation, and based on their sincere understandings of the Constitution and of precedent. I have endeavored to do the same. In my judgment, on the issue of abortion, the Constitution is neither pro-life nor pro-choice. The Constitution is neutral, and this court likewise must be scrupulously neutral. The court today properly heeds the constitutional principle of judicial neutrality and returns the issue of abortion to the people and their elected representatives in the democratic process. So there you go. That is the full concurring opinion from Justice Kavanaugh, which I feel like was well written and tried to walk a fine line between this battlefield of abortion and the debate around it. So, you know, I feel like of all the justices so far, like that has been the easiest one to read.
Yeah. I think so. Say what you want about Kavanaugh, like, he's not difficult to read. I think you can criticize him sometimes for like missing some important law. But in this particular opinion, like easier to read, easier to understand. And I think definitely a more, I hate to say it's because it's, I think this is like a radical approach the court has taken overturning Casey, but it definitely is a more like, sane line than Clarence Thomas's. And I think for all you can say about Kavanaugh, the fact that he put those statements in there about the interstate travel stuff and the thing about ex post facto clause and due process clause with respect to punishing previously had abortions, that was all good for, that'll be good for America that he put that in there. You know, that is something that, you know, this opinion and this whole thing is really bad for America. But that part of his concurrence in isolation, it's good that he put that in there, and that if he didn't put that in there, it would be scarier than what it already is. So at least I'm thankful for those meager crumbs as someone who thinks that what's going on is atrocious. Yeah.
Yeah, and I like that despite clearly taking this middle-of-the-line stance to not upset both sides and to remain respectful, that he still chose to comment on some of the legal questions that were brought up in the different, you know, friend of the court briefs that were sent to them, because he didn't have to, and it would seem to be antithetical to what he was trying to do, but he still swerved out of his lane to make comments on those and really strike them down and give people the reference needed to maybe rule on those in the lower courts later.
Yeah, I think that's that's helpful. And that's helpful. It's helpful.
Yeah.
Bookie, I propose the following. I think that there should be a next time.
Okay.
And that next time we should do Roberts in the Dissent.
Okay.
And have a stream where finally the pro-choice people can be happy.
Okay.
Is that fair?
Yeah, that sounds good to me, to package all those together, and it'll finally be some respite for the people who haven't even been happy with the crumbs that we've gotten from people like Kavanaugh here.
Yeah. And I think after Clarence Thomas is concurrence, they deserve it. They really do deserve it. They've been through a lot today.
Yeah, as much as you may disagree with the majority opinion, I think you should take special issue with Thomas's opinion there.
Yeah. Real quick, there's like some questions in your chat. Did they discuss how Thomas's opinion seems to have ignored Loving versus Virginia? I think Loving versus Virginia, even more than the gay marriage cases and the gay rights cases, you can think of Loving versus Virginia very easily as an equal protection case. Like very easily, right? That's the state is passing marriage laws that ban black people from marrying white people. Now here is the kicker. You could say, no, that law is neutral. Why do you think that someone could say that?
I don't know.
Because it bans black people from marrying white people, but it bans white people from marrying black people.
Jesus, okay.
It bans both. It it affects white people and black people equally. It affects all the racial groups equally. Now the court ultimately doesn't take that line, and I think it's properly viewed just like separate and equal. Well, it affects white people too. They're just as separate as black people are separate. Like, no, we don't think of the equal protection clause that way. I think we have like a more profound understanding of the equal protection clause now that after Plessy v. Ferguson, that doesn't just look to the formal distinctions the law makes, but also looks to like the purposes of the law and whether or not it's oppressing a particular group. And so I think that Clarence Thomas, now there's another part of Loving versus Virginia, which is recognizing a fundamental right to marriage. And I think it is shifty for Clarence Thomas to flirt with the idea that he doesn't think that that's like a thing, because I can guarantee you, if there were a law that said it's a crime to get married, for straight people to get married, for anyone to get married, Clarence Thomas would be like, that's unconstitutional. But I can't accuse him of that because it's never come before him, and he has total plausible deniability to be like, it's not before the court. And I think that Loving versus Virginia, if anyone ever accuses him of being like, why did you ignore Loving versus Virginia? For those of you who don't know, that's an interracial marriage case. I'm guessing you understood from the context of what I'm saying. But yeah. He can just be like, equal protection, bro. I don't need the substantive due process stuff for that. But then the question is like, well, why did you mention Obergefell and Lawrence? The answer to that is like, because he doesn't think those cases can be sustained on equal protection grounds. Right?
Yeah.
If the reason why he didn't mention Loving versus Virginia is because he thinks that could be sustained on equal protection grounds. The reason he mentions Obergefell and Lawrence is because he doesn't think that gay these kinds of issues implicate equal protection interests. That's why. So his absence of Loving versus Virginia, even if you take I think the most charitable interpretation of that, still says something about how he thinks about the other precedent he mentioned from an equal protection perspective. So yeah, that's my answer to that. I think that you can call him a hypocrite, but don't go crazy with it.
And it would be so interesting for him to be against that, given like his own personal situation where he's married to Ginny, and that's an interracial couple, and it's like, I don't know, that would be such a strange, but maybe he would say that though his personal opinion would be one way, constitutionally he's bound to view it a different way. I don't know.
And also, like, he probably was married in a state where they're not, like, let's be real, are any states going to pass those laws? Like, you can convince me that states are going to pass laws with respect to like challenging gay marriage. I think that even today, even with this conservative court, even with Donald Trump, even with everything we've seen so far and the coups and all that shit, I don't think that the Republican Party, even this Republican Party, even as extreme as it is going to pass laws like banning interracial marriage. I just don't think that. I think that that's not going to be a thing anymore. And so you could say in one sense he can sidestep it legally. It's probably factually never going to come up before him because probably states are never going to pass those laws again. And so he doesn't have to answer this like academic question about whether or not it undermines Loving versus Virginia, because it's a moot point, because it's not going to come up, and because he can sidestep it if it does, you know?
Yeah.
There's another question. Sorry. Hayden says, Pisco, earlier you were saying the court might strike down a congressional law which makes abortion a federal right. I think that they might on. So there's two questions to analyze when you're looking at like government enactment. One is there an individual right at stake? Right. The abortion that's been decided that no, right. There's no individual right to an abortion. The second question when Congress has passed a law is, or when any government passes a law, is does the government have the power to pass that law in the first place? With Congress is a government of limited power, and so it can only do what it's allowed to do under the Constitution. The Constitution doesn't say that Congress is allowed to regulate abortion, right? Nowhere in Article 1 does it mention abortion, that Congress is allowed to regulate it. So the only way that Congress would be allowed to regulate it is if they have some authority like implied elsewhere, like under the Commerce Clause, right? Or maybe Congress could make a federal facility, right? Congress can spend money, and Congress could say that the federal government is allowed to have abortion facilities on their own land, and states couldn't mess with that because states can't mess with the supremacy of federal law. So there are ways you can play with this. Congress could also try to codify Roe v. Wade, but that might be struck down as not having a basis in constitutional law. And so there could be a lot of problems with it. I don't think you need a constitutional amendment necessarily. I think if Congress limits itself to abortions in interstate travel or abortions on federal land, I think there are ways you could have federal abortion rights. But it's difficult, and the court might intervene in some ways. But I don't think you need an amendment, no.
Yeah, and to go back to the 10th Amendment as well, the powers not delegated to the United States by the Constitution or prohibited by it to the states are reserved to the states respectively, or to the people, which might also be part of why Kavanaugh is so repetitive in saying that, like, if the Constitution doesn't say that we have the power to rule on this, then necessarily that should be something that is a power delegated to the states, right?
Yeah, and so the other answer to that is like, yeah, Congress might be limited in what it can do here. Your solution is to do it state by state, which is like a nightmare for people who live in those states. And it doesn't look like anytime soon they're going to change their minds. But that's democracy, you know.
And as I've said before, like, you also have to keep in mind that you have more power as an individual to influence your state legislature or Congress than you ever would to influence the decisions of the Supreme Court. If the Supreme Court were to take away your right to abortion and history had gone differently, like, you have way less of an ability to remedy that. Same with the people that are pro-life now had way less of an ability to influence that decision than they would have if it was left up to the states. You have more power as an individual when the states are the ones given these abilities. And while it would be nice to have the Supreme Court rule in your favor and give you rights, it also means that you have less impact depending on the way that they rule with that. And sometimes that won't be in your favor. And it's important to consider that as well, I think.
Yeah, you're right. You're right. Easy come, easy go, I guess. And I have one last thing to say, and then I'll sign off and give you some space. For all you people like, oh, this proves that judicial review is stupid.
This was fantastic.
Like, bro,
thanks, Bookie.
Where do you think we would be if you never had Roe v. Wade? You know, we'd still have those states having those anti-abortion laws. In my opinion, I can't know that for certainty, but like, people who say that this opinion shows that judicial review was a mistake, you're mad that this court is undoing judicial review. You're mad that this court is getting rid of a time in which they did have judicial review. And so why can you be like, I hate judicial review? And what proves it is the time the Supreme Court undid striking down democratically elected laws. I think that is incoherent. You can be against judicial review for other reasons, but to be like overturning Roe v. Wade, a case which instituted judicial review against democratically enacted laws, overturning that proves that judicial review is stupid. I think you're not understanding like your own argument. That's my only take. But thank you so much for having me. Next time we're gonna have some fun. Finally, not necessarily with Robert's opinion, but with the dissent. I think it's a very well written dissent.
Yeah, and I definitely look forward to that. As like a final closing thing on these hypotheticals about the way that the court decides, like, I also think it's worth keeping in mind from reading about the history and stuff in particular off stream that had the court not decided the way that they did on Roe v. Wade, and had they decided the way the present court did, I wonder if in that historical timeline, you don't have the fervor around abortion, and actually we would have more rights today than we would have back then.
Hey, maybe that could be a good point. By interfering, the court made these camps and made it almost like when you make something a big deal to like a little kid. I hate this analogy because I'm not trying to infantilize the whole country, but like if you're like, oh my god, are you okay, what's going on, like all that stuff, if you bring attention to it and categorize it like that, people might react very, 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 very strongly to your action on it. So so actually that's a good point. You know, maybe the judicial review in Roe v. Wade did stunt some kind of natural process to abortion laws. I think that might be a little pie in the sky. I think that the opposition to abortion is more substantial than that and has to do with like religious doctrine that is easily changed. But you know, it's a good. I think Roe v. Wade definitely pissed a lot of people off, and pissing a lot of people off can make the issue be like a prominent one, and one in which everyone is like forced to have a very strong opinion on. So maybe it actually did radicalize people. So it's a decent point. But you can't be like, I agree with Roe v. Wade then. You have to be like, Roe v. Wade was dumb. You can't be like, overturning Roe v. Wade shows that judicial review is stupid. You have to be like, Roe v. Wade shows that judicial review is stupid.
Right.
Or Roe v. Wade plus Dobbs shows it. But you can't be like, oh no, we need to get Roe v. Wade back at all costs. That just shows that you just care about the result and you don't really have a problem with judicial review.
Yeah, which I think is a lot of what's going on here on both sides of the issue. But
fair. Yeah. All right, Bookie, thank you so much. Thanks to everyone. Thanks to chat. Appreciate you. And I'm signing off to go get some lunch.
All right. Have a good one. Thanks for stopping by. And I look forward to talking to you tomorrow.
Yeah, appreciate it. Bye-bye.
Bye. So for anybody interested, that was Pisco95, our resident Twitch lawyer to help us with these kinds of topics. I've enjoyed having Pisco on. Now, to give you a bit of a history on that and a history of our coverage of this case in particular, I think it was at least a month ago, if not 2 months ago now, that we covered oral arguments in this case, where we listened to the judges asking questions of the two parties involved in the case. And we already had some indication, I would say a very strong indication, that they were going to overturn Roe v. Wade. And that happened, I believe, all the way back in October of last year. And it wasn't until we had a leaked brief that people really started to realize the situation they were in. But if people had paid attention back when oral arguments were heard, it was very clear that the court was going in the direction that was reflected in the leaked brief. So we covered that. And then during that coverage, we heard from Pisco. Pisco was in the chat and you know, having his criticisms of the coverage or trying to correct things or trying to give us some information. And it's really difficult when you're in the chat to kind of engage in that way. There's a time delay, there's a character limit. It's down to how well you're able to write chats, you know, so that was difficult. So when the Supreme Court dropped their opinion, I reached out to Pisco and asked, hey, would you be interested in coming on? The one thing that I don't want us to do is be debating and arguing the whole time. I really want us to focus on the text of the opinions and have you there as a force for good insofar as educating us on what's being discussed or turning us on to things that we might miss if we're not legally minded or educated. And he agreed, and it went really well. So when we continued looking at the concurring and dissenting opinions, which are people that either want to add their 2 cents dissent on the majority opinion or detract from it because they disagreed with it. They're not legally binding, but they are something that courts in the future could reference, and they give us some indication on how the judges might, or the justices, I'm sorry, might, rule in the future. I really wanted to have Pisco here to discuss those and to discuss the majority opinion. And I hope that we can close out this whole segment looking at all of the opinions involved in this case at the end of it as a more thematic explanation to why, instead of engaging in debates or reviewing debates around this topic, I've chosen to go to the primary source documents, is because I believe that when we're talking about something like this and the entire discussion is focused around a primary source document, which is legible to the average person can read and understand what they're talking about, then it behooves us to look at that primary source document and then take our opinions from there and take the discussions from that point. And I was confident that very few people on the platform were going to go that route. It's going to mean less viewers for them. It's going to mean less support for them. It's going to be less entertaining for people. But as a very boring and maybe financially not the most successful or driven streamer, I took it upon myself to do that work. And it's been really nice having Pisco here to do a better job of it. And I hope that if you guys like this format of having me on as a layman and having an expert on to help us with these topics, that we could do more of this in the future, whether that's on the efficacy of, Dr. K's interactions with Reckful or something similar, that we could have somebody on and really have an educated opinion on that in the room, and have somebody to bounce off of who is, filling the place of maybe an intelligent layman, which is the position I'll fill. And I hope that we could do more of that in the future. I think that that's productive, and it would enable me to kind of utilize the Rolodex of people that I built up while I was doing essay writing to kind of tap them and have them come on and help. Because I think beyond just tapping Twitch people, like in the case of Dr. K maybe bringing on, not so erudite, I would really like us to bring people who are completely uninvolved with the scene, who could really give us a more objective opinion that's not coming from some preconceived notions about the topic, that are coming from discussions they've had or they've seen on the topic itself. Like, I think it would be far more interesting to see a practicing, clinical psychologist comment on the efficacy of Dr. K's interactions with Reckful, who is not somebody from the space, who is not so erudite, who's talked about it numerous times and maybe influenced by other talks that have gone on the platform, or a particular disdain for Mr. Girl and the way that they engage that might be influencing their opinion in one way or the other. And the same goes for Pisco here. It would be ideal to have a lawyer who is uninvolved in the Twitch politics space, who isn't involved in the DGG sphere of influence, who could comment on this as well. But, I think it's still good to have Pisco on regardless. And I think he's done a good job of remaining objective, not referencing those conversations. And I'm super happy that we have support for this, helps me keep doing it. CMG.
I definitely support the expert commentary arc.
Thank you. I'm happy to hear that. And thank you to the people who have been donating. I haven't been able to give you guys all the attention in the world today because, again, Pisco has limited availability, and I'm trying to work through things as quickly as possible so we don't have hours and hours of content on this. But to go back through the queue, CMG, obviously, with the $50, thanks a ton. I really do appreciate that. Jacob B with $100 saying that this was fantastic. Thanks, Bookie and Pisco. Thank you for supporting the content. If you guys make this an endeavor that can financially support me, it doesn't really matter to me necessarily how many people view the material. If it is financially, doable for me to cover these and to have these people on and to cover these primary source documents, then it's easy for me to make that decision. Contrary to popular belief in some circles, I am not a big clout goblin demon person who is making every single decision to maximize the amount of clout that we can get or whatever. if it's a financially viable decision for me and it feels personally fulfilling to cover the content and to do justice to it, that's enough motivation for me alone in those two things to try and pursue it. And I've really enjoyed our little Supreme Court arcs that we've been on. Diaz donating $4 in total with your wrong comments. Funny, but thank you for supporting the channel in your own way. And to X Hunter, who donated $100 through Super Chat, saying, "Love these law streams. Keep doing more. Thanks, Pisco, for the assist." Thank you. Thank you for supporting the content. Again, the more you guys support this, the more viable it is for me to do it. And whether that's a Mimi message from Diaz with $2, or it's a huge donation from these people donating $100 or $50, I really do appreciate that. And that enables me to keep doing this and to consider doing this in the future for other cases that might be important for, the history and the culture and whatever of the country. And then $100 from Hiffer. Have a great summer, Bookie DGGL. Thank you for showing some love from that community, and I do appreciate the $100. That's awesome of you guys, and through your continued support I can keep doing these streams and not really worry about them too much, not worry that they're taking away from the momentum of the channel, or there's something that will go unrewarded financially or whatever. It's you guys coming out and supporting that content, whether it's through $3 or $100, that enabled me to keep going. So thank you to the people that have done that. And if you check out Into the AM and you buy some clothes, you might get even more bang for your buck in terms of material wealth. And you can get some really cool shirts that last a long time, and I've been generally happy with. If you ever see me wearing these black graphic tees, those are all coming from Into the AM. And they've been kind enough to sponsor 2 months of content for the channel. So big shout out to them. And if you'd like to support the channel and get some cool threads at the same time, just use Into the AM, all one word, and then you could pick up some clothes, pick up some hats, maybe a hoodie. I really like their clothes. I have no complaints. I often have to reject sponsorship deals because I cannot support the product. They fall apart or they're awful. This is one of the few sponsors where I've actually enjoyed the product and I feel good enough to take the money and plug it to you guys, because I wouldn't feel bad if you ended up picking up some Into the AM merch. They have a lot of sales on their website that give you a huge discount. And with my code or my link, if you go to intotheam.com/booksmarts, I believe you'll get an additional 10% off of your order. And that'll help kick back some money to the channel, as well as letting Into the AM know that the sponsorship deals are worth it. So that's another way to support the channel in case you didn't want to spend money on a super chat or something like that. You could get a bit more for your dollar by going there. There's all that. I'm going to catch up a little bit with the chat here. That was a very informative discussion. Thank you, gentlemen. I'm happy you enjoyed it, Grammy. Amy performed great in oral. Jesus. If y'all stop talking about the environment, maybe some of us would care about it. Jesus, I don't know what is up with you. That was a great read. Helpful. Well, I'm happy you had me in the first half, I think learning new things is more fun than listening to 2 or more people repeat their opinions loudly at each other. I would generally agree. By the way, the Hidden Hand Society are a RICO org. I have no idea what that's about. Living ads are annoying. Well, it and your mom have something in common. The only people that Roe v. Wade could piss off are old people, since most of America wasn't alive or understanding at the time. Okay. The truth is, people agree or disagree with this based on whether or not they are pro or anti-abortion, not whether it makes legal sense or not. Sure. Which is fine. You can have your opinion on abortion completely separate from your opinion on the legal system, which is personally where I stand. I am pro-abortion. I want people to have the right to have an abortion. However, when we talk about what is the Supreme Court meant to do, or what is the proper legislative way of handling that, my opinion does not fall apart and I don't just ideologically pursue abortion. Granted, I'm not somebody that needs abortion, so that might impact my decision a little bit there, but like I moderate that opinion based on what the Supreme Court should be doing or what it ought to be doing or the arguments that it's making. And I would encourage you to do the same. And I would encourage you to put pressure in the right places, which is likely not going to be on Supreme Court justices. It's probably not the best option to protest outside of their houses or to threaten their lives. I think it's far more productive for you to be focusing on state legislatures and trying to get this codified into law wherever it is that you live, or you could even go on some, crusade to a different state to try and help the organizations there. And I think that that's probably what you ought to be focusing on. To be frank, it's what you should have been focusing on in the 50 years since Roe was put into law. I think that the entire time since Roe, you should have been working to have these things put into your state constitutions. And it's the lack of steam around that issue and the buildup of steam around the issue on the other side that likely led to where we are today. Pisco and I talked at the end about how, personally, in my mind, a lot of the evangelical fervor and people joining with the evangelicals and with the pro-life people in general came from this decision on Roe v. Wade. I don't think the fervor for anti-abortion would have been nearly as strong had Roe v. Wade not happened, had Casey not reaffirmed that decision. And while they were working to keep in place laws restricting abortion and to encourage their Congress people to be anti-abortion and to pressure the president Reagan in the 80s to be anti-abortion and so on and so forth and get the Supreme Court justices that they wanted, there were so many knock-on effects of Roe v. Wade and the kind of I don't have a better word than fervor that developed on the other side because of that decision, and just the complete lack of the same on the other side. They thought it was decided and done with. Meanwhile, the other side saw their crack in the door to kind of take away that right and to institute laws that further restricted that. And they've been pursuing that the entire time, while we on this side of the issue have been relatively complacent on the issue. And now that complacency is gone, and we're going to need to be thinking about codifying it into law. But I think that's where the focus needs to be, not on pressuring the justices to decide differently. Unless you were to have a major shift in the makeup of the court, that's very unlikely to happen. So focusing your frustrations on the court is misguided. And I think that your frustrations and your efforts need to now be focused on state legislatures and on Congress. And I think that's kind of where we need to be at right now if you're pro-abortion. Don't threaten the Supreme Court justice, threaten your state legislature. Threaten them politically. I'm very much so in favor of threatening the fuck out of your state legislature politically, okay? You can threaten to get them out of office. You can threaten to call their offices every fucking day and be annoying. You can threaten to protest outside of your state legislature building or to bug the fuck out of them. I'm down for all of that. As a matter of fact, I fall in line with like Kavanaugh's opinion that that's really where this should be decided. That's where the people have the most ability to impact things. And as a result, that should be where your efforts are focused. You have a lot more chances to influence your state legislature than you do to influence a sitting judge of the Supreme Court or justice of the Supreme Court. And that's where your efforts should be focused. I'm definitely pro threatening your state legislature politically. 110%. Yeah, I'll bite that bullet all day. The thing is, these religious nuts can't be persuaded. Politicians can. And political institutions can. Yeah, we got to make baby murder illegal in California to save the future generations of Elon Musk and Jeff Bezoses. Nice. Beg for your rights. More from sociopath politicians. Protest as long as it's orderly and meaningless. Vote harder for Dems that let this happen. I completely disagree with all of that. Furthermore, if you think that the Democrats allowed this to happen, you need different Democrats, okay? If you got problems with the way that the Democrats are operating, you can choose which Democrats you want in office. Pick better ones, dumb fuck. The thing still applies even if I take at face value what you're telling me. If you think that your politicians are sociopaths, if you think that your protests aren't having an impact on them, if you think that they allowed this to happen, then you have a clear place where you should be focusing your attention. And I don't know what to tell you, dumb fuck. I'm finally just going to block you on YouTube, Joker. Sorry, you're being a dumb fuck. So, yeah, there you go. You're bitching and moaning with no effect. Well, if it has no effect on you, then I don't know what to tell you. And if you're going to keep spamming stupid shit in my chat, I'm just going to time you out because I have very little patience for your bitching and moaning. And if you can't handle it from me, then maybe you could sympathize with why I can't handle it from you. If you're going to sit here and chat at me all day and not call your representatives or try to do something meaningful, and you just want to focus all your attention on threatening sitting justices or some other stupid thing, or typing in this chat, then who is the dumb fuck really, right? That's where I'm at with that. Time me out, poos. Well, then you're gone. Sorry. And I'm going to actually just ban you, to be frank, and you can go ahead and try and appeal that if you care enough. The issue is book smarts. We are here. Most people don't understand our system. Well, then now that you're educated, go do something about it. Or DM me and ask me what you could do about it, and I'll help you find an opportunity. Hey, don't you want to watch one music clip for 2 minutes to forget about everything for a moment? No, I think we need to remember. Arizonans thought they were electing a strong progressive. Maybe, bro. Until she turned red. Well, and then she turned red and now you elect somebody else, right? Such is life. Sometimes you marry a woman thinking she's a wonderful person, then she ends up being a crazy bitch. And at that point, you divorce her, right? So these things happen. Sometimes we misunderstand people. Such is life. I thought this was the Supreme Court. No, this isn't the Supreme Court. You got the wrong address. Has anyone read The Pelican Brief by John Grissom? It presents a third solution to unfriendly Supreme Court Pepe. No, I have not, but that Pepe's got me scared. What are you trying to prove? Absolutely nothing. Well, no, I understand our system, Lamau. I'm a law student. My point is politicians and schools do a terrible job educating the average American. Well, then go out and try to educate the average American. If you stop at a problem and you do nothing about it, then I think that you kind of need to probably just be quiet and focus on whatever problem it is that you are willing to put efforts behind solving. So if you stop at, oh, well, politicians and schools do a terrible job at educating the average American, well, then that's not very productive. You've got to go do something about it, or be quiet, I suppose, or tell somebody that actually will do something about it, which I'm hoping there are some people in the audience that will. As a matter of fact, I think I got a Twitter DM, it was just the other day, from somebody who started volunteering in their area because they watched the stream and they thought, you know, I've had enough of hearing this. Maybe I should just do this. And I did, and it was fun, and so I'll continue to do it, right? So that's ultimately the place that I hope you guys get to. And that's the place where I'll leave the stream off for today. So if you had a good time, be sure to catch us tomorrow at around a similar time. It's going to be the morning Eastern Standard Time, where we'll have Peace go on to go through the last concurring opinion from Roberts, who I understand has some issues with the majority opinion. And then we'll also go to the dissenting opinions from the other justices. So if you're a pro-abortion advocate, that's going to be your stream. And if you're an anti-abortion advocate, maybe you could get some insight into the other side on this particular topic. Anywho, without further ado, I'll let you guys go about your day, and I hope you enjoy it. Hope you, if this upsets you, you find some way to rectify the issue or be a part of the solution, not the problem. And I will talk to you guys later. Thanks for all the support, and thank you to Into the AM for sponsoring today's stream. I will talk to you guys later. See you tomorrow. Have a good rest of your day. Bye.